This one move on Monday as mentioned matter.
Mention matter.
On Monday I have seeking leave to file and move matter.
What is the urgency?
Urgency matter. Supreme Court demand the matter for fresh hearing. Authority having knowledge that in spite Director DDPS issued a vacancy notice in same location.
But may I be permitted to mention regarding 201 my lord, 2 days please, my lord. On Monday I have mentioned my lord asked me to come today, my lord.
Item number
201 my lord.
Yeah.
Yes. What is the urgency?
Urgency, my lord, the ineligible person, my lord, has been selected. My lord, while my lord, the application was made, my lord, even my lord, on the date of my lord, inquiry, my lord, the land in which my lord, the godown is situated, my lord, was not my lord, the Bastu, Danga, or my lord, commercial. My lord, it was my lord, my lord, the private respondent is ineligible to my lord, make such application. Even then, my lord, he has been selected, my lord. This is the if my lord, the allotment we give in my lord, in my petition.
Who are you? You one of the
But
applicants.
I'm the applicant. My lord, I'm second.
Do you have the eligible
Yes,
criteria?
yes, my lord, everything what I have. But even my lord, his go down was also not my lord, completed, my lord, at that time. My lord.
সোমবার কি আছে দেখ। আরো দশটা কিছু আছে। Mention matter. 201.
Yes, my lord.
On mentioning the matter be appear in the list under the heading mention matter on 18th.
Yes,
My lord, may I have your lordship's kind leave to mention, my lord. My lord, item number 207, my lord, of your lordship's list, my lord. My lord, urgency is, my lord, offer letter has been issued, my lord. And
All are urgent matters.
no, my lord,
If I want
and
to
it is sale.
upgrade, the
My lord,
matter cannot be taken
kindly
up.
appreciate, my lord, on the same location, my lord. My lord, vacancy has been declared and it's going to be filled up, my lord. My lord, offer, in spite of giving offer letter, my lord, vacancy has been declared on the same location, my lord.
Today 10:30 matters.
My lord, in this matter, my lord, Mr. Sonal Sinha is appearing, my lord. So, my lord, if your lordship desires, my lord, I can inform her, my lord.
Madam is here.
She is there, my lord. Right, it can be taken up, my lord. It can be disposed of, my lord, within 5 minutes, my lord.
All matters are 5 minutes.
Yes, my lord. This is very simple.
Let me take up the matters.
My lord,
Really, otherwise, how can I?
kindly
Several
take up to
applications,
that, my
new
lord.
mission matters. I cannot take up new missions matter due to the mentioning matters. This is the difficulty. Other matter will all will appear under mention matter.
And let it appear, my lord, let it be taken up to that one, my lord.
No, today how can I?
Then, my lord, kindly keep it on Monday, my lord. It's very urgent, my lord.
All are urgent matters.
Well, definitely, my lord. But, my lord, this is, my lord, despite giving the offer letter, my lord, license has not been issued, and on the same location, my lord, vacancy has been published. Several litigations will crop
Tuesday.
up on this. My lord, no, can I give it on Monday, my lord?
No, Tuesday under mention matter.
May I permit to mention, lordship?
207. My lord, another matter, my lord, 203.
I permit to mention, lordship, last week Mr. Parthapratimra mentioned the matter on Monday, lordship. I have mentioned, your lordship asked me to come on Wednesday, lordship. Now 171, 177, lordship, these two matters, when lordship new vacancy has been declared, lordship, I am running the vacancy covering by your lordship judgment below lordship 6,000. Now lordship, already panel has been selected. They will, if the vacancy is declared, lordship, my ration card will be shifted from my dealership.
177.
171 and 77, lordship, both the same matter, lordship. One matter, lordship, Miss Sonal Sinha is appearing.
Fix all the matters on 26 similar matters.
Then lordship 26, lordship, kindly
26 I fixed at least 30 matters on the same issue.
kindly take it, lordship, 18th or lordship Tuesday. Because lordship, already they have lordship selected the panel. Anytime lordship, they will declare the new vacancy as lordship.
All the matters are urgent matters and now you are asking
It
to
will, it will lordship take very short matter. You'll
understand. All matter take up only.
and we have lordship. একটাতে দিদি তুমি আছো
These matters 171 and 177
77 lordship.
are similar to item the matters fixed on 26th of August.
Kindly fix it 26 lordship.
On mentioning, let the matter appear in the list on 26th of August 2025 under the heading mention matters. 171, 177 দুটো separate order করবেন.
রিপোর্ট দিয়ে দিয়েছে
Yes. Group 8. Group 8 or group 1? Group 1. Restoration. Land matter.
My lord, may I have your kind leave to mention two appellate side matter, group 8 matter, my lord. On the same cause of action, two different person has filed two different writ petition. So, my lord, it should be heard together, my lord. I am petitioner in one writ petition, and in another writ petition, though they have not made me party, I have filed one application for implementation. So, my lord, both the matter should be taken together, my lord.
What is the list?
It is, my lord, in 62 and 130, 113, 113,
62.
62, my lord. Chintamani Sarkar and state. And 113, Jawabala Sarkar.
Okay, these matters.
Yes, my lord. Same cause of action, my lord,
So, Chintamani Sarkar, you are the petitioner.
my lord. And in Jawabala Sarkar, my lord, I have filed application.
So who is the petitioner there?
Jawabala Sarkar, my lord. I have informed them also, my lord.
No, no. You are not the petitioner there. So you want your matter should be heard. That is Chintamani Sarkar with Jawabala Sarkar.
My lord.
Jawabala Sarkar item number?
Item number, my lord, 113, my lord.
113. Who is for the petitioner there? See,
Shekhawat Khandewar is the learned advocate on record, my lord. I have served copy to him also. I am mentioning on notice, my lord.
without hearing, how can I? Okay, this is appearing under heading to be mentioned matter. That is,
My lord, my matter has already been upgraded, my lord, under to be mentioned one.
let it be in the list at the time of hearing. If necessary, I will take up this matter.
My lord, obliged, my lord.
Yes.
One matter you are not I am sending up on notice. That's right.
I am for the respondent corporation.
Matter hearing is already concluded. The matter has been made CAD.
Because we would like to submit written notes. So if you would kindly keep this matter to be mentioned or accept the.
Which matter?
So this was, it's a group 1 matter following the order passed by the honorable.
Yes,
division bench, the
Judgment
last-
ready. Judgment ready. You need not to submit anything.
Oh, not required. The written notes.
Why you need in notes? You have admitted entire matter.
Notes.
The view of the judgment of the honorable division bench.
Yes.
That judgment you have annexed.
Judgment. You have already annexed those judgments. Judgment is ready. You are just under correction.
Notes.
Not necessary. There is the industrial matter. Some share of dispute is there.
Yes, yes, yes.
Dispute
Regarding
there.
joint venture.
Joint venture.
formation.
Yes, yes. This matter, I know that.
May I be permitted to mention item number 210, my lord. Here the selection process has been challenged by a candidate whose candidature has been cancelled. My lord, license has not yet been issued. My lord, all I am praying, let it be under the mentioned matters heading any day subject to lordship convenience. Because in the meantime,
If by piling up the mentioned matter, all new motion matter will be
I understand
stalled.
that let it be any day.
Let me start the new motion matter
If
first.
the license is issued in the
Then
meantime,
from the Monday, I will take up new motion matters first. Let's see what can be done. One day I will take up new motion matter, one day mention matter. That would be better. Otherwise, you all starting converting new motion matter to mention matter. That would be better. Not that way. Okay. এই মানডে থেকে ফার্স্ট নিউ মোশন ম্যাটার ধরবেন, মানডে লিস্ট করবেন নিউ মোশন ম্যাটার ফার্স্ট, তারপরে করবেন মেনশন ম্যাটার। ঠিক আছে, মানডে থেকে করবেন, আদারওয়াইজ ইউ উইল স্টার্টিং লাইক দ্যাট। ইয়েস, One restoration. Group one.
Lordship, one restoration, and it's a very small matter, Lordship. Listed motion.
Listed motion, group one.
My lord.
Mr. Uda.
Lordship, my lord, yesterday, my lord, after your lordship's list has exhausted, my lord, the petitioner in item number 31 yesterday, my lord, the private respondent had mentioned the matter, my lord. It was supposed to be taken up today, my lord, but it was mentioned, my lord, that he had some, my lord, difficulty, my lord. He had to visit his native place, my lord, and therefore lordship had fixed it on 1st of September, my lord. All that I'm praying, my lord, the petitioner has been suffering for quite some time. It's a writ of 2024, my lord.
Your
But-
junior was there, I think.
Yes, but he had said that he had intimated me, my lord. He had intimated me.
You were online, I think, at the
No,
time.
he had
you were not there.
no. Otherwise, my lord, I would. The only issue is, my lord, that because of this issue, my lord, the petitioner has been suffering and my lord, would still suffer, my lord. Any day,
Today, learned advocate is not here.
I have
today.
already informed him. I have already informed that I will
When
mention
he
the
is
matter. He
returning-
said today he is in difficulty. Otherwise, any day. Any day otherwise. Today he is in difficulty. He has gone to his native place, Uttar
You
Dinajpur.
mention it on Monday.
Monday?
Monday. That is better. Otherwise, today I could not take it.
Lord, I
It's
had,
not
my
here.
lord, I had those, my lord, vacancy matters, my lord. I wanted to mention, but lordship would be taking up, my lord, on Monday.
Mention matters first. Monday first, new motion matter.
Then I would not mention, my lord, because
Yes.
new motion it will be taken.
Lord, may I have your lordship's leave to mention one group one land matter, my lord? Your lordship takes, my lord, group one land matters on Thursdays and Fridays, my lord.
Yes.
Lastly, my lord, when we had prayed for inclusion, my lord, your lordship was pleased to give us inclusion, and the matter is appearing as item number 43 in the list of last Friday, my lord. My lord, the only urgency I was beseeching is, my lord, the writ petitioners had obtained an order of status quo with regard to possession in the land since 2012, my lord. Thereafter, they have not taken any steps for hearing of the matter. The Kolkata Port Trust, my lord, who claims ownership over the land, my lord, cannot use the land for, my lord, any commercial purpose.
Thursday. This is today. Is
My lord,
not the
I was only beseeching any Thursday or Friday, your lordship, my lord, kindly fix it, matter. My lord, 20 crores of revenue every month is being lost. My lord,
No, very well. You mentioned it Thursday. Today there is no list.
today it's not there, my lord. Your lordship takes up Thursday, my lord. If it can be,
Thursday list would be there.
if it can be updated in the Thursdays list.
Then mention it Thursday. How can I?
But on Monday, I have mentioned your Lordship was pleased to direct me to come on Wednesday.
Item number?
Item number 125.
Item number 120. I will take up the 125. I will take up the new motion matter on Monday first. So your matter will be taken up. Today. Application. Item number. It can be taken up today. It can be taken up today. 72. Application item number 72. Okay. Call the matter.
Your Lordship, item number 174 of today's list. Last two occasions I have mentioned before your Lordship. This is the extreme urgency. And
Monday I
your
will
Lordship, kindly hear 1 minute. Your Lordship, on Monday I have mentioned this matter, and your Lordship was pleased to direct me to come on Wednesday. The urgency is that vacancy has been declared without considering the compassionate appointment of the
Item number
174 of today's list. Kindly fixed it at on Monday or Tuesday under heading mention matter
172.
174, my lord.
On mentioning 174.
170.
That side is
Matter Tuesday.
Grateful.
Yes, call the list. Mr. De, you supposed to argue.
Should I remind your Lordship, Lord, I beg to appear on behalf of the
Yes.
petition.
Mr. De is here. He will argue on that.
So they are you going to argue first?
Yes.
Lord, may I refer?
Mr. De shall start first today. Today you no complete. Yes. Yes, you
No, I have not cited the decisions. How can I complete?
decision, Mr. Mukherjee.
Yes.
Just yes, proceed.
I'm led by Mr. Parjiwala.
Okay.
I can give the decisions, my lord. 1979. 1979 Supreme Court, 1628.
1979 Supreme Court, 79
1628.
61628.
Because this is a famous case. Ramana versus International Airport Authority.
Give me the copy of judgment.
Yes, madam.
तो बोलो जाने Hi.
Is the copy available to your lordship?
No, they have not handed over yet.
79. 79. Hmm.
Give me the copy.
1979 is not available, madam. Do you have a copy of 1922 Supreme Court? I have. 2022 18 SCC. I have that. Kindly hand over to my lords. My lord, 1979 Supreme Court. I'm telling your lordship.
Yes.
This is Ramana versus International Airport Authority. 163. This is a path-breaking judgment. For the first time, Supreme Court held that even
Karnataka Power Corporation Limited versus EMTA Coal.
no, 79 Supreme. I'm coming to that coal matter next. I'm referring to 79 Supreme Court.
79 Supreme Court has not handed over to me yet.
We will hand it over. We'll hand it over hereafter. I'm
Okay.
just briefly indicating the point. For the first time, Supreme Court, more or less for the first time, held that even in contractual matter, a writ application is maintainable, where the state is acting unreasonably, arbitrarily, and without any reason.
Okay.
Previous view of the Supreme Court was that in contractual matter, the writ application is not maintainable.
Okay.
For the first time in this case, Supreme Court held the state is state everywhere, whether it is contractual or statutory. If in the contractual matter, the state is acting arbitrarily, unreasonably, when the state is answerable in the writ court. Secondly, the Supreme Court held that if you hold a standard for the state action,
Yes.
you stick to it. You cannot depart from it at your sweet will. I propose to act according to your standard. You cannot depart from it according to your will, arbitrary will. You will be then held responsible for arbitrary action. Thirdly,
yes,
for every action, the state must have reason to do it. If questioned, if inquired, the state must disclose the reasons, and the order itself must disclose the reasons. Otherwise, the order is bad. The order itself.
Yes.
These are the three important points held in Ramana's case. My Lord, I will cite the judgment, hand over the judgment to your Lordship. Second judgment I beg to rely upon is 1978 Supreme Court 851. আছে
আছে স্যার দিয়েছি।
Yes.
Lord, kindly turn the first headnote. I will not take much time. There is a waiting here. 678 Supreme Court first headnote. In this case, an order of the authority was challenged. The authority, we produced the order. The order contained no reason. Then they came up with an affidavit. Supreme Court said no. The validity of the order will be determined on the basis of the reason given in the order. You cannot add something, supplement something to the order under question. Kindly read the first head note.
Order by statutory authority validity of how to be judged.
The statutory function makes an order based on certain grounds.
Yes.
It must be. This judgment proceeds upon an earlier three judgments, which is referred to here. But this is a leading judgment. You cannot add something further in dispute. And if there is no reason, no ground, the order
cannot be supplemented by fresh reasons in the shape of affidavit.
Secondly, if there is no reason in the order, original order, there is no reason, it fails. Fails why? You are acting unreasonably.
Yes.
The state is answerable to the affected party for the reason. Your action is very challenged. You give no reason at all and proceed to affect me. On that ground, the order will be. Am I clear to your Lordship?
Yes, I understand.
If I am affected, I am entitled to reasons. Why? Because it is subject to challenge in higher forum. You have given no reason. On that ground, the order fails. This is, my Lord, this 1978 Supreme Court. You cannot supplement it. The order stands or fails on the basis of grounds given.
Yes.
The third ground I beg to rely upon is that judgment, my Lord, I have handed up to the Lordship. 2022, 18 Supreme Court cases.
Page number 163.
163, you have handed over to my Lord.
Yes. 2022, 18 Supreme Court cases.
I am giving your Lordship the facts of this case. There was an agreement for supply of coal. The contractor was supplying coal. Then the authorities started deducting something more on the ground of washing the coal. The contractor moved the Supreme Court, and the court will not say, under the contract, I'm entitled to the price of the coal as it is. How can you deduct something from the agreed price on the ground? I'm washing the coal. The Supreme Court is holding. Kindly look at the paragraphs.
মোবাইল এখানে রেখেছি মোবাইল হ্যাঁ চাপ নিচ্ছে
Yes.
163. Kindly look at the head notes.
Yes.
Kindly look at the head note below. Arrangement regarding coal procurement entered into by party for purposes of appellant's thermal power project. Above arrangement progressed without any dispute until Comptroller and Auditor General of India submitted report observing minimum coal rejects should be 10% per annum of total production, valued as. At first instance, appellant raised objection to CAG report, stating that quantification of coal rejects should be based on actuals, quantity of coal actually sent. However, despite such objections raised by the appellant, CAG finalized its report, which was made available to appellant. It was only after receipt of the report the appellant demanded reimbursement of 52 lakhs from the respondent supplier. Such a charge, change of stand by appellant, has not been sufficiently explained. Further, a bare perusal of the clauses, this is important. Further, a bare perusal of the clauses. Have a lordship found, my lord? Further, a perusal of clauses contained in various agreements entered into between the parties do not indicate such reductions could be made for purposes of washing charges. Agreement did not provide for it. I have entered a contract on the basis of written terms. Written terms did not provide that you can deduct the washing charges. That matter was entertained in the writ petition, and the Supreme Court said you are not entitled to deduct, refund it. It was a pure case of contract. Contractual dispute was allowed on the basis that the contract did not provide. These are the three judgments which I'm relying for the present. I'm just summing up. Originally, my lord, the state was conceived as a police state. Function of the state was to maintain law and order. State was not concerned with anything else. We go back below to the closure of the 19th century. State was not concerned with anything. In course of time, the state developed into a beneficial state. Not only police state, a welfare state, a beneficial state. The state started providing different amenities and facilities. But then that was not treated to be part of the state's function. State is a sovereign being, interested in looking after the crimes, maintenance of order, police state.
Yes.
In the course of time, the court started interfering of the state in providing facilities and amenities. But even then, contractual dispute was not.
Okay.
Police state, then beneficial state. And the third stage is below that 79 Supreme Court, Samana, where the court for the first time said, even contractual matter. Here, what has happened? I have entered into the state, issued a letter of a decision to allot me a plot.
Yes.
State issued a letter deciding to allot a plot. No plot was allotted. a decision to allot that was communicated to me. And I was asked to pay the premium. I paid the entire premium. At that stage, the kindly turn to that agreement below. Page 25.
Page 25.
Yes.
This is the letter conveying the decision to allot. No plot was allotted. And I was asked to pay the consideration money. I paid the entire consideration money. And look at the first paragraph. May be demised. Not a particular plot has been is being demised. This is a decision to allot.
Yes.
I paid the entire consideration, admitted.
Page 38.
There is one default clause. Paragraph page 26. Paragraph small I. If I don't pay, interest will be charged. I have paid the entire consideration. Then kindly turn to page 27. Paragraph triple I. Triple I, paragraph, page 27. Default clause. If you fail to make payment of the balance sum, even within 3 years from the date of issue of the instant letter, document shall stand cancelled. This is a default clause. Specifically mentioned, but I have paid, and immediately I have paid the entire contribution.
18,000 has already been paid.
Then kindly turn to paragraph F at page 28.
Paragraph,
Not
page 28, paragraph
paragraph F
F. Yes.
at page 28.
Paragraph F.
Default clause.
Yes.
Then kindly turn below to page 29. Page 29.
Yes.
I and J.
I and J.
The property was not fixed for allotment, was being developed. May I read out? No assurance of completion of development. I have paid the entire consideration money. A decision to allot has been given to me, but the property was not available for allotment. No assurance of completion of development. That the property is being developed. They have collected the entire money from me. by any specific date of the manner of such development will be given. They have merely communicated decision to allot, making it clear the property has not been developed. Then J. Physical possession of the plot will not be handed over before the premium of salami has been paid in full, in time, and the lease deed executed and registered. No assurance of delivery of possession of the plot to be selected by specific date after execution of the lease deed. They on their behalf is unable to give any specific date. Why? The property is still being developed, saying that even after the registration of the lease deed, no specific date for delivery is given. Now this is cancelled. This letter is cancelled. Kyle, it can't be lost. Paragraph below 45, page 45.
Yes.
This is the subject matter of challenge. Page 45. The last paragraph is the reason. This is under challenge, and the refusal to reconsider this cancellation is also under challenge.
Okay, I understand.
That's the second block.
Yes.
Bitika in the meantime had died.
Bithika Bonik died.
Bitika Devi died.
Yes.
Her husband and children then Lord has applied before Lordship. We applied for reconsideration of this document. That was also rejected. At page block 100, page 76. The certificate of death of Bitika.
Yes.
46. Page 46.
I'm sorry, page 46. Kindly turn to page 47. This is my prayer for reconsideration. Set aside them. You set aside them. আমাকে কোনো plot I have not been allotted any plot. Decision to allot was communicated to me.
Yes.
What is cancelled is the decision to allot.
What is page 50?
My lord, I'm coming to that.
Page 50 is, my lord, in another matter, there was the chance of hearing was given.
I'm submitting.
To Vandana Das Gupta, another person.
Yes, my lord.
Another one.
In our case, the chance was not given. That is,
We are trying to say, there is another fact. In
Yes.
the meantime, they asked me about one premises that is on in Calcutta proper, ki jayega rasta naam, but I'm telling you, Acharya Prabhu Chandra, just to say. Acharya Jagadish Chandra Bose Road,
page 42.
What is this? Plot of land and business. I'm back to refer you later dated such and such. You and request you to furnish the ownership of Anjana House, AJC Bose Road, Calcutta. And this
explaining to your lordship.
the process follow.
Because this family started a business.
Okay.
They succeeded and they wanted an office room that they have acquired. I explained to them that this is not a residence, this is an office room. Our registered office is at Acharya Jagadish Chandra Bose. And we are still residing in a rented premise. Then they don't object anything more. Then good day, say my lord.
Whether this letter is under challenge? No.
No, my lord.
They gave it up. They were satisfied. That this is not my residential premise at all. It's an office room.
Okay.
Reply.
They say that you have failed to exercise your choice for a plot. Because
My lord, reply to this letter is in page number 44.
42.
44.
The reply of 42.
45.
Was in the letter by the department land manager was in 42 and the reply by the petitioner was in 44.
Yes.
My lord, can I read? In para number 1, my lord, it is
Yes.
explained.
I was pressing this letter, my lord. Office is no longer disputed.
Okay. Yes. Anything?
There's a second, my lord. My lord, I am offered a plot of land in Salt Lake. I'm asked to choose. First thing is to indicate the field of choice.
Yes.
Out of so many plots, I am to choose one. Nobody has yet communicated to me where is the field of choice, out of which plot I will select. Wherever there is a choice, there is a field of choice. Without indicating the field of choice, nobody can ask me to do that. When they executed the allotment letter, it was being developed. No guarantee when it will be completed. No guarantee when a plot of land will be allotted to me. They say, I failed to select the plot. Give me the field of choice. Field of choice is first given and then I'm asked to choose. And they regret without. I applied for withdrawal of the letter of cancellation, they rejected. That is here below. Page 49. What is the reason? Page 49.
Yes.
What is the reason for regret? সঞ্জীবের অর্ডার। দুশো তেরো তিন। But there is no reason. Can your lordship will not examine the legality? I had a allotment decision in my favor. Your lordship is not asking them to allot. The decision to allot was taken by them. They cancelled, giving the reasons. I apply for reconsideration, giving the reasons. That is at page 44. My application for reconsideration at page 47. First, decision to allot, page 25. Nothing happened thereafter. I paid the whole consideration. Then they cancelled.
Okay.
After cancellation, I apply for reconsideration. Reconsideration rejected. No reason.
Without any reason.
Without any reason. And my lord, my landman declined to file an affidavit. In this case, there is an order by your lordship recording that the state has declined to file an affidavit. Well, I have the privilege to argue one case. Hey, boy. 2015. Thank you.
My lord, another point I add, my lord, in page number 42, my lord, the plot of land in Midhannagar, Salt Lake City, the department land manager directed me to furnish the ownership of Ajanta in 2007, where the delay was not mentioned. There was no delay mentioned.
You have a delay point, Nick Divi.
Yes, which judgment you are referring, Mr. Mukherjee?
2015 and 13. 13 CLT.
486.
486. Look there.
Yes, sir.
The read petitioner was declared to be willful defaulter for inability to pay off the dues of the bank. Willful defaulter.
Yes.
The petitioner made a representation giving reasons. And I'm not a willful defaulter. And the bank authorities rejected it. The rejection order was under challenge before Justice Sanjeev Banerjee. His Lordship has given reasoned judgment. Kindly paragraph 234. More important is paragraph 6 and 7. If your rejection, 6 and 7, if your rejection is without any reasons, six, seven, willful defaulter was issued against me. I made a representation that was being considered and rejected. Simply rejected. From paragraph 6, kindly read the illuminating judgment. It was hard for 3 days.
Yes.
In my case also, my application for reconsideration has been simply rejected. Kindly turn me Lord to
Yes.
order was quashed. The other point, my landman, my landlord junior was wanting. And in the meantime, they asked for Ajanta house. They didn't complain about any delay. They were inquiring the ownership, about the ownership of Ajanta office. At page 42.
To furnish the ownership of Ajanta house.
No question of any delay. Mitika died. I was establishing my business. I acquired the office premises. And then I wanted to rake up the question of having a residence of my own. Now, Lord, if they say they have not yet said, then I will finish the point. The question of delay doesn't arise. That's all.
Okay. Yes, you start.
Reference to your application for allotment of a plot of land.
Page.
Page 25.
Yes.
With reference to your application for allotment of a plot of land, Salt Lake City extension, Salt Lake City extension in under the government. I am directed by order of the governor of West Bengal to state that a plot measuring about 3 kathas, more or less, in sector 1, 2, 3 of Vidhannagar Salt Lake County will be given to you on these for 1999 years subject number. That is the condition. And in this, my lord, there is specific condition. What is the condition we should guide?
Yes.
You must, that is the lessee must follow that direction. Now, A, the plot will be available on lease on auto years, payment of premium or salary charged at the average rate of rupees only per kata, provided, however, you have to pay extra charges in the following advances. That is the chart I cannot want. You are given option to deposit salary. How the salary will be paid? Now, payment are my Roman 1, that is payment of full amount of salary or premium calculated provisionally at the said rate in one installment within 90 days for the date of this letter, and the balance salary as may be finally calculated on the basis of actual measurement of the plot and the location of the plot. Well, this is very well, you can note it. Why?
One installment within 90 days from the date of allotment.
That point not, my lord. I am mentioning that the
Balance amount has to be calculated.
Advocate of the senior counsel put that point. Where is the land? What is the amount? What is the land? My lord, it's a very clear state cut. You have accepted this. You must go through it. You can't, my lord, deviate from it. What is deviation? Deviation is calculated of the basis of actual measurement 90 days to the date of this letter, and the balance salary has been finally calculated on the basis of actual measurement.
Yes.
When actual measurement will be done, that will be the latter part. But Roman 1, there is a specific stated that the measurement of the plot and the location of the plot also, after selection of the same, there is a provision of selection. After selection, up till now, up till the selection by the my lord Vitika, that is the dead person, that is Vitika is made, my lord. It is can't be calculated. What is the actual amount? What will be paid?
So first selection.
First selection. For that is, my lord, actual measurement of the plot and the location of the plot, all are, my lord, mentioning after selection of the same. Selection will be made by the, that is erstwhile, my lord, that is Vitika. Within 90 days, my lord, there is a specific date. After selection of the same, selection within 90 days from the date of demand, following with interest of 7% will be charged for first 2 years and other percent third year. My lord, payment of 50% of the said salary within 90 days from the date of allotment order, and the balance of the salary calculated on the basis of the aforesaid with the account. If the payment is made within first 2 years and interest 10% of the third year, it is from the date of issue of this. Now, my lord, this is very Roman. If you fail to make payment of the balance sum, even within 3 years from the date of issue of this letter, the allotment shall stand cancelled, and salary already paid by you will be refunded after deduction from administrative charges of rupees 50. The amount of salary deposited to government will not be herein. Now, my lord, that is the salary or part of the aforesaid will be deposited that the amount I may not want to go into. Now, my lord, no assurance and land development work proceeded. Now, my lord, J. Physical position of the plot will not be handed over before the premium or salary has been paid in full, in time, and the lease deed executed and registered. No assurance of delivery of position of the plot to be selected by you by specified date after execution of the lease deed is given. Correct? There is also specific date. Any amount paid in excess of the premium or salary as may be my guideline. After full payment of all the dues, you will have to get a that is drawn up, executed, and registered within the time limit prescribed. All expenditure thereof will have to be borne by you. A certified copy of the lease deed will have to be made over by you to the government within 60 days from the date of registration of lease deed, and you will have to take delivery of position in your plot as and when performed. Failure to take delivery of position of the plot within the specific time may lead to cancellation of the allotment and resumption of the plot in the appropriate manner, and in the given amount of salary paid by you will be refunded after determining therefrom rupees 50 and additional. You will be required to construct your house within 3 years, madam. All money is payable by you government under the agreement of lease shall apart from the after remedies available on the government realized as a public demand under the West Bengal Recovery Act and statutory ordinance. The government will get liberty. If my lord, that is key is very important. The government will get liberty in case of any default on your part to observe, perform any of the obligations listed therein before the cancellation of allotment and the before the cancellation ballot, if there is a yes before this ballot, that will be cancelled. What is the condition ballot? Condition is specifically stated that ballot in page 26, Roman 1. That is payment of full amount of the said salary. Ballot 26.
Yes.
Roman 1.
Yes.
Payment of calculated provisionally at the said rate in the installment within 90 days from the date of this letter, and balance salary shall be finally calculated on the basis of actual measurement of the plot and the location of the plot. After selection of
So what is the
after
condition?
selection of the same my lord.
So
My lord, within 90 days, he must select the land.
no. After select the land, the payment
After
of full.
selection of the same, when within 90 days from the date of demand following with interest of assets.
First installment within 90 days from the date of the letter. This letter.
My lord, that part is not very necessary.
Okay. Then
Condition is, my lord,
after selection.
On the basis of measurement of the plot and the location of the plot.
Yes.
After selection of the same. My lord, he must select the land.
So within 90 days from the date of demand.
Yes, my lord.
What demand?
That is, I am coming on this that.
Yes.
Now, my lord, date of demand following which interest will be. That is the condition.
So who should select?
That is the party will be select. That is Vitika.
Where are the lands to be selected?
Selected, my lord, I request. That is the authority will request him to come and select the land.
Yes. Whether authority has asked him.
This is the land you must take.
These are the lands you take, you select.
Those lands are for you. You can select.
You choose and select any of them.
That is the condition, one of the conditions. And now, my lord, in P, there is a specific abatement of that is, in case of any default, not
Yes.
a particular and so many defaults. In any case, on your part, to observe perform and any of the obligation, receive, herein you cancel the allotment and then. If you can prove, my lord, that is, we can perform all our duties. But the Vitika, he is not performing his duties. Then, my lord, our petitioner, this is not. Now I can show, my lord, because lordship will see. The government shall not liable to pay any compensation in the event of government failure to allot for plot of land to give department of the data.
So the now question is whether government has shown some plot to choose.
Yes, sir. Now I am coming.
Yes.
Why I may not want to all the matter, my lord, in the
Okay. All the document, all everything is there.
my lord, in this petition. For that is my lord, I may not want to choose to file the
Affidavit.
Each information should be sent to the undersigned under registered post at the end. After creating 50% of the full amount of the salary which after commanding, each information should be sent to the undersigned under registered post letter and should reach him before 150 days of after following the allotment of the offer and scan and of least percent of the after 90 days as accepted.
Yes.
Now, my lord. Now, my lord, page
40.
Yes. Okay, my lord.
31st July.
31st July 2006.
31st July 2006.
And my lord, the agreement is made, my lord, on
19th of April 89.
1985. And this, my lord, application is made on 31st July 2006. Since to inform you that 3 kathas of plot of land on Vidhannagar Salt Lake was allotted in my favor under Metropolitan Development Department Government of Procedural. Dated 1999. Now, kindly take it note that Odonta India Private Limited is our family business, and I am one of the directors of that concern. Some business trouble and disturbance, I could not select
Any plot of land.
I could not select any plot of land. After 11 and 6, after 17 years, he wrote a letter to us. What is the conclusion? That due to some business trouble, it is not my lord, he annexed it. Due to some business trouble and family disturbance, I could not select any plot of it. It is admitted position. That is the terms and condition which is in the my lord agreement that was my lord violated by Vitika. And he wrote in a letter in the 6th of 31st July 2006 after 17 years. Now
Yes.
I overcome business and family trouble. My lord, now my lord, it is very serious matter. Within 90 days that should be done. But what is now, that is on and from 31st July 2006. At the point she was not ready. Now he is ready. Now I overcome the business and family trouble and in a position to start the construction work as soon as the pending formalities for selection of the plot. That is also admission for selection of plot. Now he is ready. And registration of lease deed is completed. I have already requested the concerned executive engineer in this regard. Under the facts and circumstances, I request you heartily to realize my earlier difficulties and allow me to select. On that day, he prayed first time that gives me a chance to select. What has brought after condoning unavoidable delay, so that I can register the lease deed and take up the construction. Now, my lord, this is a admission one. So I can't want to prove. They prove that after 17 years, I request the authority to give me a chance, and I never selected. Now, my lord, page 41.
Yes.
This is before you that a 3 land township application for effort was allotted in my favor, due payment of selection. Now kindly take a note that is 20 June. The family business, that is the kindly note that is the family business of all concern. During the relevant one, I am one of the business director. These are the stewards of the business director. That go there, go to us and select the. This is the member of that concern. During the relevant point of time, I was heavily engaged in expansion of our business. Why not clarified again? Not for hectare or dealer. My lord, I was heavily engaged in expansion of our business. That is the excuse for delay of 17 years. Within the state as well as in the other state of India and abroad. Outside my family business, there were duties and negligence to carry. Now I am in a position to look after my personal life and found that I had not selected the plot at Salt Lake City, which was allotted to my. Again, he stated by Lord that I have not selected, that you have not selected. He said, I have not selected the.
She admitted.
Yes, my lord, that is a clear, my lord, admission. That is request you to realize my earlier difficulties and condone the unavoidable delay in selection of the same. I now request you really to condone the delay and allow me to select that. Now, my lord, that is the. I am directed to refer to your letter dated in the above mentioned. Request you to find the ownership of what is the. That is not the practically, that is not the issue in this application. In this application issue is that is 3 katas of land or not. So I may not want to go into that. Page 44, my audience down. Thank you very much. In 54, my lord, that is first
October.
2007. He replied to your letter dated and after is the part of letter of which myself and my husband are the proprietors.
That is Ajanta House.
Yes, madam. This is not a residential. I hope that you are satisfied with my above reply. Now I request you to note that I have but after a lapse of so many years, government has not earmarked any particular plot of land in my favor till yet. As such, my lord, now the first time he raised a point, the government has not
earmarked.
As such, this deed has not been executed and registered. The above amounting to the APO was lying with the government since 18 years. I have not provided any more money and material then from the same table. I request you to kindly augment the Tata plot of Salt City and you need to complete the following. Now, my lord, 45.
Impugned order.
Yes, ma'am.
Impugned.
Challenge, sir. Now, my lord, whether this is a reason order or not. What is called reason order? Reason order means, my lord, whether there is a reason which is known to everybody
Yes.
and there is any ambiguity. That must be very simple. And, my lord, it is very easy to everybody to know what is the cause of that. Now, my lord, I am coming for answer of my landed senior.
Yes.
Whereas a plot of land measuring about 3 katas was allowed in favor of Srimati Deepika Boni. Under the Department of Order number in 1904-1989. And whereas Srimati Deepika Boni, that point was never raised, but that point was never agitated. And whereas Srimati Deepika Boni was requested by the said SIRS circle to choose a plot of Salt Lake City on 4th November 1989 and 4th September 1989 and 25th October 1991. We requested our mother to come and select your plot. Not only one,
Twice.
or twice. For our mother, necessary as to because they felt that their natural justice was not given to us. We have given the natural justice. It is pro moto, he should come. But in the previous letter, he said, I am very busy with abroad and the business of the abroad and other things. So it is not possible for me to go to you to select the land. And now he is coming before this honorable court and said that is all illegal. And this is not a reason order. What is reason? Reason is we have given twice. Come in 1989 and 1991, come and select the land. It is not the property, my lord. Property is a very now is a very high risky zone, my lord. That we must ask everybody to come and select and take your land. Otherwise, my lord, there is so many different. There is very disturbance and other things there. And in 1999, after 2006, she first time she said, I am giving that. Now, my lord, and whereas Srimati Boni has not approached the department to choose a plot of land and Salt Lake City within the city.
1984.
Yes.
I say this is a specific reason order. Now, whereas Srimati Deepika Boni, who has later dated 31st July 2006, had requested the department to complete the pending formalities for selection of the plot and to complete the registration of the land. That is his letter. 1989, that is the offer letter, and my lord gave answer this my lord, that is
2006.
And whereas it appears that on clear of Deepika Boni for confirmation of delay for choice of plot and other formalities in the registration of ministry without any justifiable ground for the lapse of more than 17 years from the date of other offer letter from 1904-19. And my landed senior counsel, my lord, argued that there is no necessity of delay or anything else. This is a land This is not the paper transaction or anything else. It is a land property. Property is any time can be disturbed by anybody. So when the government is wanted to give you, offer you something, those persons should come at once. But twice we have given for the cause of natural justice, we have given him chance, but he failed to do so. For what? Not for Hillel or not for another subject, but for his business purpose, not only here, but also abroad. What is the use for taking a land of the Salt Lake City? So those poor persons take a chance. Now, my lord, that is the final reasoning order. If your lordship will come next paragraph. And whereas it appears
Yes.
that she has failed to fulfill, that is the most reason order, has failed to fulfill the terms and conditions of the offer letter errato, and has failed to take delivery of position within the civil period, the offer of allotment stand cancelled. Previously, my lord, we give the reason, and now terms and conditions of the offer letter, and that you violated the terms and conditions of the offer letter, offer stand cancelled, and for that reason that was stand cancelled, and determined in terms of the offer letter. The refund of salary was deducted as administrative charges to be considered on submission of their with all liquidity documents by Singapore. I submit before your lordship. This is more than a reason order. A person who is given a chance to allot a plot of land, my lord, in our in West Bengal, my lord, there are so many persons who are searching only very small plot of 3 acres. They are not getting that chance. But a person who is a big rich man, he got a chance. He will not take the chance. So, or we asked him, we requested him to come and take. In spite of that, he refused to do so. And my lord, after that, after a lapse of 17 years, he said, now I am very ready to get the same. Whether it is possible for any purpose, the land should be wet for a person who is going here and there, he will get the chance. This is not a disorder. I submit to your lordship, this is more than a disorder than than the judgment which was given for the cause of submitted by the government senior counsel. In all the manner, no reason order, and other things, my lord. And delay, my lord, that delay which is caused, this is damage to everybody. If the petition is not allowed, then everybody will take a chance. That state has not any right to say anything. We can take, and after a lapse of 17 years, 20 years, we go there and ask them to give me a chance. If not, we go there to the Honorable High Court or anything else on the court of law, and we will get the chance from the court. That is the principle. That can't be a principle of this anybody's matter. So I pray, my lord, this petition should be rejected with cost, my lord. Not only that.
কষ্ট দিয়ে
Hey, please,
কষ্ট দিয়ে না বিনা কষ্টে নয়
now. I love this is my son. Mr. Jaina, also.
Okay. Reply today.
Yes, I just asked. স্যার রিপ্লাই দেবেন আজকে পরে হ্যাঁ
My lord, asking me anything?
রিপ্লাইটা আপনি আজকে দেবেন স্যার
Mr. Dey has concluded his argument. So
I have
when
to give, I have to give it 5.
কবে রাখবেন আমি তাহলে সেরকম প্রেয়ার
তবে
করব
জজ সাহেবের সুবিধা হবে।
okay, okay.
I'm sorry for this intermittent conversation just to
No issue, no issue,
facilitate my lord the
no issue. Okay.
যবে স্যার বলুন যবে বলুন
জজ সাহেবের যাবে সুবিধা হবে।
হ্যাঁ হ্যাঁ এই তো স্বাধীনতার পরই হবে স্যার স্বাধীনতার পরে তো
হ্যাঁ, স্বাধীনতার পরে তো হবেই হবে।
সেটাই বলছি পরাধীন ভারতবর্ষে আমরা রিপ্লাই দেবো না স্বাধীন ভারতবর্ষে দেবো 14ই আগস্ট কিন্তু আবার পাকিস্তানের ইন্ডিপেন্ডেন্স ডে 14ই আগস্ট পাকিস্তান
22nd of August, 10:30.
in independent India, my lord.
22nd of August.
After 15th, so independence, after independence.
Lord, except 22nd, any other, I have back 22nd. Any other. Yes, yes, in the morning, your lordship will hear me.
হ্যাঁ মর্নিং
10:30.
সকালে হ্যাঁ
Let it be there.
22nd.
Argument on behalf of Mr. Chondi Chorande, learned AGP, behalf of the state authority concluded. Let the matter appear in the list on 22nd of August 2025 at 10:30 for argument in reply on behalf of the petitioner.
আমার ছেলে কবে আসবে গো? তোমরা কবে আসে? আমার এই যন্ত্রটা লাগিয়ে দেবো, এই যন্ত্রটা লাগিয়ে
তাই বলে এইটা ধরে নেবেন না যে হারানো উচিত কিন্তু জাস্ট ওটা লাইটার নোট লাইটার আমি প্রথম শুনলাম চণ্ডীবাবু কোন সময় এসে কস্ট চাইছেন আমি আজ অব্দি শুনিনি আমি বললাম স্যার আজকে কি হলো কোন ধূমকেতু পতন হলো
Okay.
ওটা ওই প্রেয়ারটা উইথড্র করে নিচ্ছি আপনি আমাদের চা খাইয়ে দেবেন ওটাই কস্ট
আগে লিভ করতে হবে তারপরে
হ্যাঁ
এখন list আবার সাড়ে বারোটা একটা রাখুন চট করে একটাই ম্যাটার 12:30 হ্যাঁ ঠিক আছে রাখুন রাখুন একটাই ম্যাটার
yes yes
2 to 7.
yes Raj
Lord, your lordship would be kind enough to take up the third application, that is CO 2462 of 2025, because the first two matter, it was in connection with two of the orders that was earlier being passed. We filed it with the application couldn't be heard out. So subsequently, your lordship, the subsequent four matters, your lordship, we had challenged the entire proceeding. So your lordship,
Where is the opposite party? Mr. Banerjee. No, only one point is there, whether it was decided by a cornered bench. The issue
that is
only
101, your lordship, CO 101, that is at page 71.
Yes.
Yes, lordship. Page 71. That is the finding of the Honorable Coordinate Bench of this Honorable
Page
Court.
71.
Yes, your lordship, page 71.
In this matter, page 62, I think. CO 101.
Yes, your lordship. No, I'll be, my lord, referring to page 71, your lordship, that is paragraph 12. That is the finding of the Honorable Court.
Yes.
Yes. In this context, my lord, I will tell your lordship. My lord, we filed After the decree, we had to execute the same. We put the decree in executions.
You are the owners.
We, yes, Your Lordship, the owner, landlord.
Owner, landlord, the decree for building and rebuilding purpose
Building and
by the Honorable Supreme Court.
Yes, Lordship.
After building and rebuilding, the tenant may get poison. This is the directive.
Yes, Your Lordship. Even after passing the formal decree by the learned trial court, my lord, we had to put it in execution because the tenant did not part with possessions to us, so we had to put it in execution. While the execution case was pending, in the same execution case, the tenants, the judgment data tenants, they filed applications for taking back the possessions.
Yes,
In one of the
observation
applications,
coordinate bench? I understand.
yes,
What is
one
the-
of the applications we filed, we came before this honorable court challenging the said proceeding by the learned executing court, being the small causes court, this order being passed, wherein the entire proceeding was set aside by issuing a fresh notice, by directing this particular person, this particular tenant, to file fresh application before the executing court, that's allegedly being executing court, that is the small causes court. I'll place this paragraph on your lordship. In this context, it is to be made clear that though the petitioner has taken a plea of maintainability of filing such application before court below, stating that under section 18A, such execution proceedings lies before controller after completions of building, rebuilding work, and execution proceedings before court below is not maintainable. But in my considered opinion, such plea is dubious in nature, since petitioner himself alleged that the application before court below is premature. Premature was made in the sense that the building was not complete, and the application being filed by the tenant, judgment data, that was the ground, that's the conclusions of the learned court below, that the application is premature. That's what we had stated in our application. And that's why, that is the reason for holding this, coming to the conclusion that it is dubious. Such plea is dubious in nature, since petitioner himself alleged that the application before court below is premature. In one hand, we said that this is not maintainable under section 18A, and at the same time, as we have stated, that it is a dubious as it is premature application. That is the contradictions the honorable court hold, that it is a dubious one. Judgment of the apex court was passed as per the provisions of section 13(1)(f) of the Act of 1956, and the trial court was directed to pass decree and consequential orders in terms of section 18A of the Act. The petitioner herein even obtained possession from tenant opposite party by executing decree before trial court. Now he cannot take the plea that defendant tenant cannot get back possession by executing the same decree from the court below. Well, this is, your lordship, this is the finding of this honorable court. Definitely, your lordship is a coordinate bench, but this is totally contrary to the finding of the honorable Supreme Court, as well as of the finding, as well as the statutory provisions of section 18A. My lord, as regards your lordship,
where is the observation of our Supreme Court?
Yes. Page 24. First in the judgment. This is a part of it. It is from the middle of it. Yes, lordship. Para 6.
Yes.
Section 13(1)(f) of the Act, providing one of the grounds for eviction, that reads as that. Now, subsequently, section 18A of the Act confers a right on the tenant who is evicted under section 13(1)(f) of the Act to be restored to possession in the constructed building as laid down therein. The court has to specify, while passing a decree for eviction under section 13(1)(f) of the Act, the period within which the rebuilding has to be done. But this has been done by the learned trial court while passing the consequential decree, that within 1 year, you have to make the construction work. So part of the provisions of section 18(1) or 13(1)(f) has been complied with. Subject to a right in the court to extend the time in appropriate cases, on completion of the building, the petitioner has to be offered to the tenant If the landlord does not put the tenant in possession, the tenant is entitled to approach the rent controller for a direction in that behalf. Well, this is very clear. As far as there is no ambiguity in it, this is a clear and simple direction that is of the Honorable Supreme Court.
Yes.
And for consequences arising thereof. In other words, the Act confers a right on the tenant evicted under Section 13(1)(f) of the Act to be put back in possession of the premises after his rebuilding. The provision also contemplates that in appropriate cases, the tenant may be put in possession of such part of the building, rebuilt premises as the rent controller may specify. As there is no argument based on Section 13(a) of the Act, it is not relevant for the disposal of this appeal. So this is, Your Lordship, the finding of the Honorable Supreme Court. Now, this is the judgment. There's a decree also in that regard. I'll place, Your Lordship. My Lord, I'll be placing before Lordship Father another paragraph. At page 40, my Lord, at page 37.
Yes.
Yes. This specifically speaks of, Your Lordship, that the landlord is required to follow the provisions of Section 18. That's what it speaks of. I'll place it there before Lordship. That under Section 18(a) of the Act, the landlord in a case of eviction under Section 13(1)(f) of the Act has the obligation to put the tenants back in possession of the rooms in the reconstructed building. That is an obligation attached to any decree for evictions that may be passed under Section 13(1)(f) of the Act. Certainly, any attempt to defeat that obligation under Section 18(a) of the Act cannot be encouraged and should be put down with an iron hand. In other words, the landlord will be pinned down to his obligation under Section 18(a) of the Act. My Lord, the learned executing court had acted only on this basis. It proceeded entirely right from the beginning on the basis of this paragraph only, paragraph 14. It is my obligation to put the tenant back in the possessions, irrespective of the fact that the entire proceeding, the maintainability of the proceeding, or whether the learned court below, assuming the determinations of having the determinations of to execute the matter, whether actually means actually following the judgment and decree of the Honorable Supreme Court or not, or whether means pursuant to the provisions of Section 18(a). Irrespective of all other aspects, the learned trial court is merely proceeding on the basis of Section 50, means this paragraph 14 of the judgment. And it was the specific submissions of all the means in all the cases by the tenant, that is the decree holder while taking back the possession. They were harping on this only. Paragraph 14. My Lord, subsequently it was the possession was which was with regard to, Your Lordship, construction area, how much area to be given to the tenant, that has been dealt with. My Lord, at page 40, Your Lordship. At page 40, my Lord, it has been stated that the modified plan will be produced as the plan by that time has expired. And further, there is, as per the area of a particular tenant that they're going to get after deduction. My Lord, these provisions where the Honorable Supreme Court had directed the learned trial court to pass a formal decree. As it is stated out here, the modified plan will be produced by the landlord before the trial court.
You are reading?
At page 40.
40.
Yes, Your Lordship.
Modified plan.
Yes, Your Lordship. The modified plan will be produced by the landlord before the trial court so as to enable that court to pass formal decree for eviction and consequential orders for the tenant being put back in possessions in the reconstructed building as directed above in terms of Section 18(a). My Lord, this is it. And subsequently, last, my Lord, at paragraph 16, Your Lordship, the judgment was passed. We direct the trial court to expeditiously pass decrees and consequential orders in terms of Section 18(a) of the Act. That page 41. we direct the trial court to pass the consequential decrees within 3 months of it being approached either with the existing plan or with the modified plan by the landlord. As we have directed above, the parties will appear before the trial court for seeking appropriate directions for further appearance on 14/5/2007. But pursuant to this direction, my lord, I will place the decree also subsequently. My lord, decree starts from, your lordship, at page 44. There are 7 separate decrees are there. My lord, this is a common decree that's been passed in this. It starts from 44. My lord, kindly take 46.
Yes.
Yes. It speaks of the same thing. The modified plan will be produced by the landlord before the trial court so as to enable the court to pass formal decree for eviction and consequential order for the tenants being put back in possession in the reconstructed building as directed as in terms of section 18A of the Act. We trust the concerned authority when approached before this will take note of the fact that our directions is in this interest of the sitting tenants in the building and that the little modifications needed in the plan is permitted without violating any of the building laws. If the plan as such does not require any alterations in the light of our directions as per the relevant building laws, treating it as only an internal adjustment of the space on the ground floor and on the first floor, it will be open to the landlord to adopt such stand before the trial court and seek decrees for eviction with consequential directions in terms of section 18A of the Act. In that case, the trial court will satisfy itself on that aspect. We are sure that the trial court will expedite this passing of formal decree for evictions in terms of section 13(1)(f) of the Act in the context of section 18A of the Act by imposing whatever conditions that are required in terms of the statute. We therefore allow these appeals and hold that the landlord is entitled to decrees for evictions under section 13(1)(f) of the Act. We direct the trial court to expeditiously pass decrees and consequential orders in terms of section 18A of the Act when removed in that behalf by the landlord. My lord, we direct that the trial court to pass a consequential decree, and this how the decree was passed. My lord, then your lordship, the trial court starts from page 58, the trial court's decree. At page 59, from the middle of it, the defendant is directed to vacate the suit premises within 1 month from the date of receipt productions of sanction plan by the plaintiff. The plaintiff is directed to put back possession to the tenant in the reconstructed building within 1 year from the date of delivery of possession. So this is, my lord, the decree passed by the London trial court. My lord, subsequently, your lordship, as I told your lordship, that within 1 year they filed, the tenants came back and filed their applications before the small causes court and challenging one of the petitioners order being passed in favor of one of the tenant. We challenged this before this honorable court in CO 101 and of 2021. And my lord, your lordship, finding, your lordship, he had looked into, had placed the finding. That is the finding of the trial court, of this honorable court. Now, the subsequent orders I had placed before lordship, that they had specifically stated, it is hold that since section 47 is not maintainable in one case, and subsequently, my section 47 application, wherein I had specifically raised certain points. That one, your lordship, the court below cannot go behind the back of the decree. First thing. Second thing, your lordship, so if that be so, my lord, the small causes court doesn't have the jurisdictions to proceed with the execution case. First thing. And second thing, we had further stated that the person who are claiming themselves to be a tenant, who are the tenants? The person, my lord, I don't think they had paid any rent since 1988, since the date of filing of the suit by the tenant.
That is already a separate issue not to be decided in this court. So,
Lord, section 47.
What is the order you are aggrieved?
The entire proceeding.
Entire process.
Definitely.
Entire proceeding.
Yes, Your Lordship. And it is there, Your Lordship, if Your Lordship may turns out. The
So
two,
why
two
you have not
orders,
challenged the order passed by the coordinate bench, Justice Mukherjee?
that I will come, Your Lordship. I'll be placing with Your Lordship, relying on Article 141 and 142. And certain two to three decisions, a part of the decisions I'll be placing with Your Lordship. Wherein, Your Lordship, on pursuant to that, Your Lordship, I'll be humbly submitting with Your Lordship either to follow which order to follow by Your Lordship, whether the judgment and decree of the Honorable Supreme Court or an order that's being passed or an observation being made by a coordinate bench of this Honorable Court. Now, if Your Lordship thinks that there is some anomaly, that particular issues is required to be decided by Your Lordship, then, my Lord, there should be a reference to this for decisions of this thing. Or otherwise, if Your Lordship finds, as it be evident from Article 141 and 142 and the subsequent finding of the Honorable Supreme Court, if Your Lordship find that to follow the provisions of, to follow the dictum of the Honorable Supreme Court and the provisions of Article Section 18A, Your Lordship may pass orders, Your Lordship.
To place the judgment.
Yes, yeah, I will. My Lord, kindly take the order impugned. We had specifically stated two orders of order number 21 and order number 22, dated 17/1/2025 and 13/2/2025. The first order, Your Lordship, order number 15.
Order
dated,
number 15.
Yes, Your Lordship, dated 21/8/2024. My Lord, two petitions are filed, one under Section 47, read with Section 151 CPC, filed by the decree holder applicant, and another application for recalling order dated 15/7/2024, filed by the composite decree holder. These are filed by the tenant, one by us, the first Section 47 application filed by my client, and an application for recalling filed by my learned friend's client, the tenant. The case record is taken up for hearing of the petition under Section 47, read with Section 151. The provisions of law quoted in Section 47, which specifically relates to the executability of a decree. But here the contents of the petition clearly signifies that decree holder applicant wishes to withhold the execution of the order dated 15/7/2024, thereby enabling the judgment debtor to get back possession of the tenanted room after completion of the rebuilding work, which is not permissible under the law in terms of provisions of Section 47. Actually, Your Lordship, my Lord, there was no consideration of my application. It was not done, simply being turned down.
Now, it has been observed that under Section 47, the executability of a decree can be under challenge. But you have not challenged in the application the executability of the decree. Whether you have challenged it?
Yes, Lordship. That's what you did.
Have challenged it?
Yes.
But it is observed that you have not challenged.
But the petition, I don't think I have it with me out here. We didn't objection to the application.
Applicants wishes to withhold the execution of the order.
How may not withhold? Withhold means when I make an application, when I say that you don't have the determination to proceed with the execution case, so that tantamounts to withholding. But does it, Your Lordship, entitles me to just get out of it? I had raised the pertinent questions. I simply stated that you don't have the determination or jurisdictions to go behind the back of the decree. And I kept on doing that, Your Lordship. And every time, my Lord, kindly take the last one. The next page, Your Lordship. The next order, order number 16. Order number 16. Dated 13/11/2024. Petitioner is thus directed to give a copy of the application to the OP, who is liberty to file OWO. In the meantime, learned advocate for the OP makes submissions in respect of his petition under Section 47, which has already been rejected by this court. My Lord, in whatever way I am making any applications or making any objections or any submissions that I am making pursuant to all the applications that being made by the tenant out there before the trial court, means before the executing court, I can make out at this stage, Your Lordship, I can make out a new case, save and except to simply make submissions before the learned court below that you do not have the determinations or jurisdictions to proceed with the execution case as per the provisions of section 18A, as well as per the finding of the Honorable Supreme Court. And this is the finding of the trial court, Your Lordship. My Lord, kindly, Your Lordship. Your Lordship would kindly take the order dated 27 January of 2025. 27/1/2025. Order number 21. Yes. At this juncture, it would be pertinent to mention that the objection raised by OP regarding the execution case being not maintainable, or his emphasis on the provisions of Section 18A West Bengal Premises Tenancy Act
You are reading
1956.
page, order number 21
21, Your Lordship.
at this
At
juncture.
the last page.
Last
Page of 2020, 70, means order number 21.
last page one. Okay. At this juncture.
Yes, Your Lordship, at this juncture. At this juncture, it would be pertinent to mention that the objection raised by the OP regarding the execution case being not maintainable, or his emphasis on the provisions of Section 18A West Bengal Premises Tenancy Act 1956 would not stand, since such objections raised by him before by filing other petitions have all been rejected. As a matter of fact, petitioner have filed this execution case in pursuance of order passed by the Honorable Court. Can you take this? As a matter of fact, petitioner have filed this execution case in pursuance of order passed by the Honorable Court at Calcutta in CO number 101 of 2023. It should be 2021, I think. 2021 OC. Of 2021, whereby petitioner has been given the liberty to file separate execution proceedings for execution of the decree passed in ejectment suit number 480 of 1988. In the meantime, petitioner is directed to take proper steps for execution of the decree. OP is given liberty to file copies of necessary orders passed by the Honorable Court. So, my Lord, this is the finding of the London Trial Court. Now, Your Lordship, I had placed the provisions of the finding of the Honorable High Court, that of a coordinated bench of this Honorable Court, and why my application, why the order was passed, that I had placed. My Lord, Lordship, 18A I did not to place before Lordship. I'll be directly placing, my Lord, I have one copy only. Constitution.
Constitution টা দাও। ওপাশে আছে। বড় বইগুলো, ওই যে ওই বড় বই। দাও।
My Lord,
Yes.
Yes, Lordship. Article 141. 141 or 142? Law declared by Supreme Court to be binding on all courts.
Yes.
The law declared by the Supreme Court shall be binding on all courts within the territory of India. And the next one, Your Lordship, Article 142. enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. The Supreme Court, in the exercise of its jurisdictions, may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provisions is that behalf is so made in such manner as the President may by order prescribe. Subject to the provisions of any law made in this behalf by Parliament, the Supreme Court shall, as respect the whole of the territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery of productions of any documents, or the investigations or punishment or any competent of itself. So, my lord, it is there, the 141 is there, and 142 is also there. My lord, I'll be just referring to certain judgments, your lordship, before lordship, and placing certain provisions. Lord, one is, your lordship, State of UP and others versus Ajay Kumar Sharma and others. This is reported in, your lordship, AIR 2015 SCW 6578. My lord, only 2-3 paragraphs I'll be referring to. My lord, kindly turn to page paragraph 10, your lordship. It deals with precedents, principle of precedents.
Paragraph 10.
Paragraph 10. Time and again, this court has emphatically restated the essentials and principles of precedent and the state decisis, which are a cardinal feature of hierarchical character of all common law judicial system. The doctrine of precedent mandates that an exposition of law must be followed and applied even by coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts. That is to say that a smaller and a later bench has no freedom other than to apply the law laid down by the earlier and larger bench. That is the law which is said to hold the field. Apart from Article 141, it is the policy of the court to stand by precedent and not to disturb a settled point. The purpose of precedents is to bestow predictability on judicial decisions, and it is beyond cavil that certainty in law is an essential ingredient of rule of law. A departure may only be made when a coordinate or co-equal bench finds the previous decisions to be of doubtful logic or efficacy, and consequentially its judicial conscience is to perturb and aroused that it finds it impossible to follow the existing ratio. The bench must then comply with the discipline of requesting the Honorable Chief Judge to constitute a larger bench. If binding precedents, even of coordinate strength, are not followed, the roots of continuity and certainty of law, which should be nurtured, strengthened, perpetuated, and proliferated, will instead be deracinated. Although spoken in a totally different context, we are reminded of the opening stanza of the poem, The Second Coming, authored by William Butler Yeats. The lines obvious do not advert to the principles of precedent, but they are apposite in bringing out the wisdom of these ancient and venerable principles. turning and turning in the widening gyre. The falcon cannot hear the falconer. Things fall apart. The center cannot hold. Mere anarchy is loosed upon the world. In the context of interminably citing all decisions delivered by this court, the Constitutional Bench in Union of India and another versus Raghuveer Singh, dead by his legal representative, etc., was made the following enunciations of law. It is not necessary to refer to all cases on the point. The broad guidelines are easily deducible from what has gone before. The possibility of further defining these guiding principles can be envisaged with further juridical experience, and when common jurisprudential values linking different national systems of law may make a consensual pattern possible, but that lies in the future. My Lord, I have nothing more, Your Lordship, to define, because that is the principle what has been defined in paragraph 10 only. It goes on, Your Lordship. And another judgment, Your Lordship. Scope of Article 42, 142.
Yes.
Because paragraph 20. Second last page, Your Lordship. This is, my Lord, this is the division bench of the Honorable Supreme Court in the case of M.C. Mehta versus Kamal Nath and others. It's reported in, Your Lordship, 2000 AIR SCW 1854. The scope of what Article 142 was considered in several decisions, and recently in Supreme Court, Bar Association versus Union of India and another, by which the decisions of this court in reference Vinay Chandra Mishra, the alleged contemner, was partly overruled. It was held that the plenary power of this court under Article 142 of the Constitutions are inherent in the court and are complementary to these powers which are specially conferred on the court by various statutes. This power exists as a separate and independent basis of jurisdictions apart from the statutes. The court further observed that though the power conferred on the court by Article 142 are curative in nature, they cannot be construed as power which authorize the court to ignore the substantive right of a litigant. The court further observed that this power cannot be used to supplant substantive law applicable to the case or cause under considerations of the court. Article 142, even with the width of its amplitude, cannot be used to build a new edifice which none existed earlier by ignoring express statutory provisions dealing with a subject, and thereby achieve something indirectly which cannot be achieved directly. My Lord, what I humbly submit for Lordship is the provision is there, Section 18A. My Lord, if your Lordship pleases, my Lord, I will place it.
Old Act.
18A of the old Act. I'll place it for Lordship. I have the copy. Place, my Lord, the provisions of Section 18A. Restoration of tenancy where decree of recovery of possession is passed under Clause F of subsection 1 of Section 13.
Yes.
Where the court passes a decree for recovery of possessions of any premises on the ground mentioned in Clause F of subsection 1 of Section 13, it shall specify the period within which the building or rebuilding or the addition or alterations on or to such premises shall be completed and may on the applications of the landlord extend such period from time to time for good and sufficient reason. My lord, the first portion, your lordship, that the within which the time period within which the constructions to be completed, that has been done by the London Trial Court in its decree. Second portion, on the completions of the building or rebuilding or the additions or alterations or to such premises, the controller may, on the applications of the tenant who has been ejected from such premises made within 3 months of the date of such completions, and after giving the landlord an opportunity of being heard, by order direct the landlord to put such tenant in possession of such premises or such part thereof as the controller may specify in his order within 14 days of the date of order. So, my lord, this 18A subrule 2, it specifies the controller to take appropriate steps with regard to repossessions of the building by the tenant, by the evicted person. And the last one, your lordship, if on such order, if upon an order being made under subsection 2, the landlord fails or neglects to deliver possessions of such premises or such part thereof as is specified in the order of the tenant within the time specified, then the controller shall execute the order and put the tenant in possession of such premises or such part thereof, and in that event the tenant shall be liable to pay fair rent in respect of such premises or such part thereof from the date of delivery of such possession. So, my lord, out here it speaks about the execution of the case, 18.3. Yes. Yes. So, my lord, under these circumstances, I leave up to your lordship to pass orders.
Okay.
Obliged, lordship.
4 minutes left. I'll just not summarize my submission because possibly I'll not be able to finish within 4 minutes. I can come back at 2 p.m. if your lordship directs me, lord. 2 points have been taken basically. First is that section 18A, controller has jurisdiction, the executing court does not have jurisdiction, it cannot proceed. This is the main foundation of his argument. The second point is that the Supreme Court's directions have been flouted by proceeding with the execution, and the previous direction of the Honorable High Court, which says that it shall go to execution, that also, as per his version, that is also violating the Supreme Court order. These are the two submissions made. Now, lordship, not kindly once comes back to section 18A. 18A subsection 2 would be relevant.
Yes.
Because on completion of the building or rebuilding or the additions or alterations on or to such premises, the controller may, on the application of the tenant who has been ejected from such premises made within 3 months of the date of completion, and after giving the landlord an opportunity of being heard, by order direct the landlord to put the tenant in possession of the premises. So, the rebuilding has to be completed. After the completion, after 3 months, this plot fructifies. So, 18A can be filed. Now, kindly, my lord, how not they're suppressing and misleading the courts again and again. This was not the previous application filed before the Honorable High Court. Now, they have not removed this paragraph, but I have brought the copy. Kindly see, my lord. What was their stand on oath? When the execution was filed, what he did, the clever landlord, he constructed the entire building, but the ground floor where the tenants are to be put in possession, he
What
did
is
not.
this?
Paragraph. This is the previous application in which the order has been passed by the coordinate bench. He challenged the execution proceeding on the same ground. Kindly see paragraph 11 once, it says that the application is premature because the building is not complete. So it is his stand on oath that the building is not complete, so it is premature. So if it is premature, there is no scope to file section 18A and go before the controller. What he did, the landlord, he got possession of the property after the decree of the Supreme Court, constructed the entire building, only the portion where the tenants were to be put in, did not complete that portion. The walls were not raised, it was not finished, and the entire building was completed. That is why he has said that the building is not complete. Now, in this position, 18A would not arise because unless he says and the building is actually completed, finished, 18A will not come into play. So this point was turned down in the first round, that you cannot say because you yourself say that the stage of 18A has not come. But is the court then powerless? Because the specific decree has been passed by the Supreme Court that all directions, decrees and consequential orders are to be passed to put the tenant in possession. So that is the specific direction. He's talking about not Supreme Court's order, and he is every day he's flouting Supreme Court order. Kindly, my lord, now. So first, my lord, my submission is that 18A is not, my lord, a bar because of this fact, because he is not completing this portion. And one more thing, my lord, lordship kindly comes to order number 18 once, my lord, because that was the position in 2021. He filed the application in 2021, building not complete. Kindly come to order number 18, my lord, he has annexed all the orders in the front of the petition. Order number 18 dated 21st August 2024. What was the execution for? I'm just reading, my lord. The provision of law, this is not 1, 2, 4th paragraph. The provision of law quoted in section 47, which specifically relates to the executability of a decree, but here the contents of the petition clearly signifies the decree holder applicant wishes to withhold the execution of the order dated 15/7/24, thereby enabling the judgment debtor to get back possession of the tenanted room after completing of the rebuilding work. So through the court, I am trying to get it completed. You complete it and hand it over. So in 2024 also same position remains. He does not complete the tenanted portion. How not he is flouting the order? He has come before your lordship and talking about Supreme Court's order being violated. Who is violating? Now, already 160.
Yes.
Should I come back at 2 or not 2? Tomorrow.
Not 2 and 2. I have fixed matters.
Then any day your lordship fixes, my lord. Because not he is doing the same thing again and again, but I will be praying, my lord, for exemplary cost. Previous round, this honorable court clarified, no, execution shall lie. Again, he is filing same application. 18A, I have shown to your lordship what he is doing. He will not hand over possession. He has got his building back. Now he will not rehabilitate the tenants. That is his intention.
20th August. Intake. 19th at 3 p.m. 19th.
Fine. I'm grateful, my lord.
Obliged, Lordship.
Please take down argument on behalf of the petitioner concluded. Argument on behalf of the opposite party is continued. Let the matter appear in the list on 19th. 19th at 3 p.m. All the matters same order. ওইটা দিয়ে দিন, এটা দিয়ে দিন। Okay.
Before my lord takes up the matter, my lord, I have an item number 13.
1-3.
1-3. My learned friend is Mr. Pinaki. My learned friends are all appearing on behalf of private respondent as well as the state respondent. Now, my lord, I have a very important personal difficulty. My auntie has been admitted to Amri Hospital at Dhakuria, and I have to take a discharge at after this 2. I do not know what will happen. So, if your lordship, my lord, kindly gives me an accommodation.
No issue. When it would be available?
My lord, any day in the next week. Any day which suits my lord, in the next week. I have to leave the court only for mentioning before the.
Please, please.
না এটা এখন কিচ্ছু বলতে হবে না।
Okay. No. I shall not hear your objection also. Item number 13. Item number 1-3.
1-3, my lord.
Let the matter appear in the list. On
officially fixed.
Sir, report served.
I did not get private respondent.
Serve the report.
একটা কপি দিন না দাদা, একটা কপি দিন না, একটা দিয়ে হারিয়ে ফেলেছি আমি জেরক্স করে দিয়ে দিচ্ছি। আরে আমি হারিয়ে ফেলেছি, একটা কপি চাই, আমি জেরক্স করে দিয়ে দিচ্ছি, দিন না।
25 2 p.m.
Yes.
25.
25 Millard especially fixed if it should. And Millard, one thing more, Millard, one report has been filed.
Yes. Have you got the report?
I very well. I will take it from him. I will take it from him.
If you want to use exception only within that period.
Well, exception is already filed, my lord.
Exception filed?
Yes, my lord.
I did not get copy of it.
Exception already filed, but I read you. Only one problem, my learned senior will submit it before lordship. You know, I am told by my learned junior that in the meantime, they have decided that they will grant the license. Name has been published. In favor of one person, that is private respondent number 7, who is the private respondent.
My lord, so far as the prayer for interim order is concerned, I have some objection, my lord. Initially, there was no interim order. Let the matter be heard out. At this stage,
if they issue,
okay, let it appear on 25.
Yes, on that they kindly decide it on.
In the meantime,
report in the form of affidavit filed on behalf of the respondent number 1 to 4 be taken on record.
In the meantime, no steps taken, my lord. In the meantime, only 25.
No.
I have objection to this.
They have already.
Yes, call the list.
Yes.
My lord, please honorable court has fixed the date today, but item number 24, but there is no chance today, I think.
Why not today? Why no chance?
24, item number 24.
I will take up this matter.
Then I am ready.
You wait it there.
All right.
May it please.
Lordship,
For the Union of India.
yes, for the Union of India. Lordship.
Yes.
Lordship has heard.
You have
these-
already argued on over that point.
over the affidavit. Lordship,
Over the
I was just going to start with the documents relied upon, even though your lordships have heard, but still we keep, we have to keep crossing those because each batch is giving the relying on certain documents which are very vital, lordship.
Yes.
Which therefore, lordship, I'm starting with what has been relied in the writ petition. Lordship, my affidavits are the same. It is our stand that we have not, I mean, nobody has been deprived of their stage, I mean, what the benefits, what has been done is we have corrected. What they ought to have got is what they are getting.
Okay.
What they got was not that was not legal. We have rectified the error, and now what they are earning is what they are entitled to. So we've brought them to their entitled position. It's not a question of reduction. It's not a question of deprivation, but they've been brought back to the entitled position, Lordship. Lordship, the petitioners have, Lordship, if you Lordships recapitulate, that they have relied on a memo dated 8th of August 1979.
Yes.
That was where there was to be parity within Lordship. I'll just come to, if your Lordship comes to page 69 of the writ petition. Lordship, I'm just placing the memo. The issue of revision of pay scales of IACS and the Bose Institute for the non-academic staff, consequent to the revision of pay scales of these staff in Calcutta University, was discussed with the President, Director and Registrar of IAS and Registrar of Bose Institute, when it was decided that the following points should be kept in view during the revision of pay scales. There should be parity between IACS and Bose Institute in adopting the pay scales. The principles behind in the Calcutta University pay scales should not be deviated as to preserve the link with their pay structure in order that any further revisions that take place could be implemented when they arise without further complications in future. The revision of pay scales should not be done and should include the other conditions imposed by the Calcutta University for such. Therefore, Lordship, Calcutta University, it was getting at par. Calcutta University is also imposing revisions. I mean, Lordship, the next paragraph, subject to the above principles being followed, the Government of India has accorded to the adoption of the pattern of pay scales of the non-academic staff of Bose Institute in accordance with the conditions of the grant in aid of the institution. Lordship, this is the crux of the matter. The grant in aid has certain conditions.
Yes.
It's not that it can be done according to anybody's whim or fancy, Lordship. So there had to be a parity. There had to be conformity with the grant in aid. There had to be conformity with the Calcutta University so that there are no complications in future.
No,
And
the
Lordship,
situation in the 1979 was otherwise. The Calcutta University was there.
It was Calcutta University, maybe, but Lordship, see the underlying principles.
Grant in aid.
It was grant in aid. You have to go to work according to the terms of grant in aid. Calcutta University pay scales, Lordship, it has been, there should not be done, it should not, Lordship sees the revision should not create any complications in future. So the analogy that it should not be more than the central government employees, what we find now, what was the reason for us rectifying. Lordship, even then, Calcutta University pay scale. So, Lordship, that was what at par with Calcutta University.
Yes.
So this was the crux, and according to the conditions of the grant in aid, Lordship. Here too we have done according to the conditions of grant in aid. Lordship will come to the next page. The next page, Lordship, is the document dated 1st of August 2001. Now, 1st of August 2001 is a document of the DST where
promotion policy of non-academic staff.
Non-academic staff, Lordship. Lordship, here, Lordship will kindly see paragraph 2, I'm skipping paragraph 1. The above mentioned promotion rules were discussed at a meeting, and in the meeting, the broad conclusions were arrived at. Promotions of administrative staff will be vacancy oriented. In other words, such promotions have to be against vacancies arising against sanctioned posts and cannot be made on time-bound or interim supernumerary basis, Lordship.
Yes.
Lordship will kindly note that what has been done is an absolute violation of this instruction. In this regard, the principles evolved in the meetings held in the DST on July and February regarding promotion and other matters should be kept in view. Thereafter, there is no objection to the ACP scheme of the central government civilian employees as introduced in DPTOM dated 9th August. So, Lordship, it was either vacancy based or ACP. Lordship, in here, Lordship, therefore, in 2001, the approved promotion policy was either vacancy based or ACP. Therefore, that was absolutely very clear. There was no, I mean, there was no scope for any misunderstanding. There was no scope for evolving any other alternate mode of scale of pay. That was done, Lordship. Lordship, now, Lordship, I was just taking your Lordships through the annexure, the minutes of the 164th meeting of the Council of Bose Institute, Lordship. That is at page 72. Now, Lordship, if your Lordships could kindly come to agenda at page 76. That is the agenda number 164.11, Lordship.
Yes.
Lordship, here, that repetition of the 2001 memo has been made. The director apprised the House that in the 163rd meeting of the Bose Institute Council, the matter of promotion of non-academic staff was placed in detail with an advance copy to DST for approval. The Bose Institute non-academic staff do not have a well-defined promotion scheme. However, after several years of discussion and efforts, the DST had finally recommended 3 promotional modes for administrative technical staff. One was a vacancy-based promotion, and the second is the ACP, Lordship. And the Mana scheme is not applicable to this batch of that we have discussed in the earlier. I'm not repeating that. Therefore, Lordship, in consideration, so this was even in the meeting held in 2004. Therefore, Lordship sees 2001 the policy is framed. 2004 they take it, Lordship. Thereafter there is the chart, what was approved, what was not approved, and there we find that even then promotions were given not in the regular way. Beyond, I mean, I'll just take your Lordship, what was just to bring out what was happening. Lordship will kindly come to the next page, page 77. Promotion under the ACP scheme. 16 employees were recommended under the ACP scheme, out of which 11 employees, although completed 12 years, is the of continuous service in their grade after the last promotion, did not complete 24 years from the date of their joining as required under the ACP scheme. Since they got the first promotion after 7 years of service, as per previous tenure, the director requested the council to waive this minimum lag time as one-time concession. Therefore, ACP had a time factor. Here, there we find, Lordship, this, I would say, faltering or we could say cutting the thing to to the size of both institute as they required according to their convenience. So what was actually granted was the promotional policy was vacancy based and ACP. And I just placed this to show the conduct that there was this trend to accommodate people who were not eligible, Lordship. That is why I have shown that. This is one trend. Wave, we've done, it's a mistake, let it that be wave. This was the trend that was being followed. Lordship, Lordship, therefore, Lordship, 2001 policy framed, 2004, we were following, both institutes following that policy, maybe praying for waivers, maybe praying for certain concessions, but basically that policy was following. Now, Lordship, if your Lordship comes to page 86, page 86, this is, Lordship will note the date, that it is a emergency meeting of the chairman of the academic departments, heads of the scientific sections, including chairman, chairperson, academic affairs committee, and all the academic heads that met on the 8th of April 2008. This date is a very, very significant date, Lordship. Now, I'm placing the entire document, Lordship, because this gives the entire scenario of this episode relating to the pay scales. The director informed the House that the non-academic employees of the Institute, both administrative and technical, met him on the 4th of April 2008 and expressed their deep concern for non-implementation of the revised structure and career advancement scheme in the Institute, while those benefits have already been implemented both in the IACS and the S.N. Bose National Center for Basic Sciences. The employees also appealed to the director to implement provisionally those benefits as had already been implemented in the IACS and at the S.N. Bose National Center for Basic Sciences on the basis of the office memorandum of Professor M.G.K. Menon. They, both the Employees Association and the staff union, also agree in writing that in the event the DST is in a position to chalk out a formula for bringing parity among all the DST-aided institutions, and in case it is observed that the employees of the IACS and the S.N. Bose National Center for Basic Sciences are required to pay overdrawn amount, if any, we shall also remain agreeable to make refund thereof in the same manner. Therefore, Lordship, the entire institution was involved in this, in the new pay scales that they had taken unto them, I would say, at par, apparently at par with the IACS, with effect from 22nd of December 2005. Lordship, everybody was involved. And prior to the provisional granting, the employees had agreed that we will return if there is no parity. We will refund the amount, Lordship. Because thereafter, he informed that in the council in its 168th meeting held on so-and-so approved the report of the Structural Reforms Committee, but the report was still under consideration, Lordship, of the DST government, but the report was still under the consideration of the DST government of India. The issue was again considered in the 169th meeting, wherein the council approved the 6-tier ST system and the promotion scheme for the academic scientific staff. Regarding recommendation of the non-academic staff, the council informed that the DST Government of India would finalize its examination and inform the council within 3 months. So nothing was there at that point of time. They would do it. Everything is provisional. Employees undertake to return if there was overdrawal. In absence of any response from the DST, even after constant persuasion, the office memorandum of Professor M.G.K. Menon, the then Secretary DST, Government of India, was placed in the Finance Committee in its meeting held on 7th of January, and the Finance Committee considered that office memorandum and fixed an extraordinary meeting of the Finance Committee on the 31st of January 2008 in the chamber of the Joint Secretary. The Finance Committee, in its extraordinary meeting held on 31st of January, discussed the contents of the office memorandum at length and recommended that there was no scope for any further discussion by an empowered committee. Accordingly, a meeting of the council was arranged on the 21st of March. The council considered the meeting of the Finance Committee, and the chairman agreed that there should be parity with IACS and Bose Institute in terms of pay structure and other benefits of the staff as indicated in the office memorandum of Professor M.G.K. Menon. However, Dr. Ramaswamy, in his capacity as the Secretary DST, Government of India, informed the Council that not only should there be parity between IACS and Bose Institute, but among all other autonomous institutions of the Ministry of Science and Technology, Government of India, and such measures were already underway at the level of the ministry that would be implemented with proper approval at the earliest. Lordship, all this time what is being referred to is that 8th August 79 memo, the
M.J.K. Menon.
M.J.K. Menon, pay scales at par with Calcutta University, but approval was subject to the terms of granting it, and again, there should be no confusion with Calcutta University. So the employees of Calcutta, I mean, they should, the same analogy that is
IACS, Calcutta University.
IACS, Bose Institute at par, nobody has any dispute.
Yes.
The same. But again, the Calcutta pay scales should be in parity with Calcutta University as well. Again, the central government pay scales, what they are facing now is to have parity with the central government employees. The director also read out the contents of the office memorandum from Professor M.G.K. Menon and thereafter sought the opinion for implementing the revised pay structure, career advancement scheme of the non-academic staff of the institute provisionally, with effect from 22nd 12/2005, keeping parity between IACS and Bose Institute as per the decision. So this entire decision is a provisional decision. Although Professor K.P. Das and Professor Shati Sen Mandi expressed verbally their reservation for the issuance of such order without the absolute approval of the council, however, the House felt that unless the scheme was implemented, even if provisionally at the earliest, it would be impossible to maintain peace and harmony within the institute. So this was actually why the scales were implemented with such haste. It was agreed to implement the benefits of the institute exactly at par with those of IACS, subject to the condition that the overpayment, if any, made thereby consequent to an otherwise decision by the council would be recovered from the employees in a suitable manner. It was also informed that only current effect and notional benefits will be accorded on receipt of the prescribed option form from the employees to this effect, and no arrears would be made. No arrear for revision, the arrear for such revision shall be made only on receipt of concurrence from the competent authority, Lordship. Therefore, there was no permission from the competent authority. Council was unaware, and as I said, they have given unto themselves a pay scale. A mode of promotion, promotional policy was not what was approved by the government, but was given unto themselves. That is I think that is the best way it can be worded. The House further decided that at present benefits which should be allowed prospectively and the accrued arrear for the adoption of such revised pay structure and career advancement scheme, if any, would be paid simultaneously to both the academic, non-academic staff of the institute after approval of the competent authority. The House further requested the director to constitute an implementation committee. Therefore, this was a meeting held on the 8th of April. Lordship, on that very date, Lordship, if your Lordship comes to page 91, 8th of April, provisionally it has been approved. 8th of April, an office memorandum is issued. On that day itself, I mean, before going to the council, before going anywhere, it is on that day the office memorandum is issued. Therefore, Lordship, even and how is the office memorandum worded, Lordship? In pursuance of the terms of reference of the office memorandum dated 8th of August 1979, 8th of August 1979 of the DST, Government of India, read with the report of the Anomalies Committee constituted by the then Secretary DST, dated 3/2/1987, in accordance with the instruction contained in the Ministry of Department of Economic Affairs, Government of India, dated 17/11/1983, and in anticipation of the formal approval regarding parity between both institutes, an office memorandum being issued in anticipation. And others, ISCS and other similar DST-aided institutes, the director both institute, having been satisfied that the revised pay structure and career advance scheme was implemented in the Indian Association for the Cultivation of Science, and on the recommendation of the meeting of the heads, departments of the sections held on the 8th of April, have been pleased to order to implement the identical revised pay structure and the career advance scheme of the ISCS for the non-academic staff of the institute provisionally with effect from the same date, that is 22nd January 2005, for keeping parity between both institute and the ISCS, subject to the conditions of the overpayment, if any, thereby made consequent to an otherwise decision of the competent authority, shall be recovered from the employees in a suitable manner. Therefore, Lordship, everybody knew it was provisional. If there is no approval, there is a chance of recovery. Lordship, nobody was unaware of that fact, Lordship. At all stages, I mean, all the employees, their representatives had submitted in writing. And the office memo also, it was issued in anticipation, and that the employees had on the condition that in case something goes wrong, in case there is no approval, then it will be refunded, Lordship. Lordship, now this therefore, Lordship sees that 8th of April was the decision. 15th, the pay scales are 15th April. I don't think that. Lordship, 8th meeting of the Finance Committee, 8th April. 8th April, office memorandum issued. 15th April, revised pay structure published. And then, Lordship, this is placed at the meeting held of the Council held on 29th October 2008. That, Lordship, will find in page 103.
103.
Yes, Lordship. It starts from page 100. That is the 171st meeting of the Council. And it is, this was the action taken report on the various decisions. Agenda 171, if your Lordship comes to Lordship comes to page 102, serial number 4, that is
Yes.
right at the bottom. It is item of the minutes was 170.4, and the particulars were adoption of pay structure and promotion scheme for the non-academic staff of at parity with Lordship, both technical and non-technical of the institute at par with the IACS in the spirit of the letter of Professor M.G.K. Menon. The Council noted that the action taken report as under. Based on the decision in the 170th meeting held on 21st of March 2008, the Director, on the recommendations of the Implementation Committee, had provisionally implemented the word, stress on the word provisional, provisionally implemented the identical pay structure and promotion career advancement scheme as in force in the IACS for the non-academic staff of the institute with retrospective effect from the date of 22nd of December 2005. Further, to accord promotion to the eligible non-academic employees, both technical and non-technical, under the newly adopted promotion career advancement scheme. The Assessment Promotion Committee, comprising of 7 members, had been constituted, and in pursuance of the recommendations, the recommended candidates were promoted, upgraded. The list of promotees is enclosed. The Council endorsed the actions taken by the Institute in this regard. Lordship, pausing for a moment. The actions of the Institute were provisional. And what they endorsed was that provisional action. So throughout what we've been hearing, that the competent authority, which the Council in my humble submission is not, this has to get, since it's a total, it is a fully granted aid institution, it has to get approval from the Department of Expenditure. The DST has to get its approval from the Department of Expenditure, Lordship. So what was actually approved, Lordship? What was given? Everything is provisional. Nothing was, so this decision is a provisional decision which the Council had accepted. It was not a decision taken in, with the, I would say the decision was taken with being fully aware that there were chances of it not being approved. And the Council had endorsed provisionally. The Director had said provisionally, and the Council also endorsed that decision. Lordship, I just place it, endorsed the actions taken by the Institute, and the actions were totally based on the understanding that is being done provisionally. Whatever has been done provisionally, knowing fully well that in case there is no approval, we will have to return, they will have to, they are ready to refund whatever extra has been given to them. So that was how this decision had come into being. Therefore, it was not that a mistake had happened at one sphere. Employees enjoyed that benefit and now it's being taken away. No. Everybody, there was a lot of, I would say, democracy. Everybody was involved in this decision-making process. In fact, the meeting was held because the staff had I mean, there was a constant pressure from the employees regarding the pay scales. So everybody was fully aware of what was happening. Everybody was fully aware of the fact that it might have to be returned. If there was no approval from the competent authority, there is, and the entire office memorandum, which has been issued on the same day of the meeting, I would say with great haste, Lordship, which has been issued on the understanding.
On the teeth of maintain peace and harmony.
On the teeth of maintaining peace and harmony. So it's not that we were not, the employees can say, or that we were unaware, we've been enjoying pay scales and now it's being taken away. This was not the situation then, Lordship. Therefore, Lordship.
Today?
Lordship, I haven't finished, Lordship. Actually, I have another matter which can be taken up. But I'm just continuing, Lordship, but I had spoken to Mr. Bhattacharya because he has an assigned matter also, which he wanted to do. Mr. Shaunak Bhattacharya, I was speaking to him and said that you come, because I have to go to courtroom number 4.
Okay.
Lordship, so, but I have not concluded, Lordship.
I understand.
But this is on the factual aspect, Lordship. And then I will be coming to the formation of the group of officers, that is. So this gives the background of how, yes, that I'll be coming to that stage, Lordship.
Please take down argument on behalf of the continues. Let the matter appear in the list on the
My lord, sorry to interrupt your lordship.
20th at 2 p.m.
Lordship.
My lord, 20th. My lord, perhaps your lordship has a division bench, my lord, on 20th. Subject to correction, my lord. 20th, subject to correction. There is a division bench where your lordship is a, my lord.
Okay.
Can it be anytime earlier?
27.
27.
Well, can it be sometime earlier?
No, Wednesday.
My lordship, can it be on other day, 27, 28?
Let the group first and go thereafter.
Let
them
my lord.
7. Yes.
My lord, I appear for the petitioners in 9 to 11, my lord.
I understand.
Great privilege.
Lordship, orders may be passed for 9, 10, and 11.
All separate orders, 8 to 12.
8 to 12.
8 to 12, all separate.
Which 20 for 27?
27.
27.
8, 10, 11, 12. Separate.
Separate. 8 to 11.
So grateful, my lord.
Yes.
8 থেকে 11 8 থেকে 11ই তো হ্যাঁ 8 থেকে
12 is another matter.
12 is not our matter. No.
Okay.
Post Institute? No.
8 to 11. Up to 11.
No, 8 to 11.
Call item number 12.
Grateful, my lord.
12 for the state, my lord. Mr. Bondapada was about to conclude, my lord. He's on his legs, my lord. Kindly, my lord, another date, my lord.
Monday.
He concluded. Grateful, man.
Only not today. Next. Pass it over next. 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 17-1, 1st September. Next. Next. So Monday তে আসবে, all Monday. Yes. Next. Call the list. Next.
My lord, I am paying for only not this week, my lord.
22.
22.
It will appear Monday.
Next month.
Next. No one is there. On the list.
My lord. My lord, on previous day, Honorable Court directed me to file reply on affidavit in opposition. I have filed, I have already served. Please take the copy. And one more point here, each and every day in cause list, if this has a name is coming, not my name. Office told me without specific order from Honorable Court, that cannot be changed. Necessary direction may kindly be given in this regard.
Which matter?
In the list, copy list. Mr. This is not in can I am the lawyer. And order sheet also passed. I have filed Allotment, but each and every day in the copy list, Mr. This name is coming. That may kindly be corrected.
report না ওনার নামটা দেবেন can 1 of 2025 মানস চক্রবর্তী মানস কুমার চক্রবর্তী অর্ডার না করলে হবে না আচ্ছা ঠিক আছে আজকে অর্ডার করব yes what is the matter
My lord, in this case, my previous lawyer can I am telling can file an WPA that after filing it without the order of the without the instruction of the petitioner, his junior Jahanara Begum, as per the instruction of the senior lawyer, he submits before the Honorable Court that petitioner want to withdraw the case. But the case is not like that. Petitioner never give any direction. Petitioner totally in dark in this regard. Honorable Court handicapped hearing this. It was withdrawn. My humble submission. I would like to contest this case. I have filed this case with an hope to have justice. This is very unfortunate. Why he has placed this submission, I do not know. May kindly be.
What is the opposition of the state?
Obviously, the state is. State has not come yet now. Obviously, state has filed his affidavit opposition. Yes, filed, but I am not looking him here. And my lord, one more point. I have filed in ruling of Honorable Calcutta Supreme Court 1980 AIR page 400 that for the fault of the lawyer, client should not suffer his inaction, misdemeanor like this. And one more ruling I have filed also with this application, my lord, that it is also Honorable Supreme Court that in this ruling categorically it is told that state, it is the duty of the state, my lord, to say that not only defend the state, but also defend the petitioner. Because clearly it is mentioned on the Supreme Court.
You have said, you have submitted Mohabir versus State of Haryana.
That is para 96. Para 96, my lord, kindly go through it. This two ruling will help me to reach the conclusion.
Have you served upon Miss Jahanara Begum?
Yes. She did not receive it, so what can I do, my lord? 2 times, 3 times, going his office through summon and through phone, 3 ways. Even his senior also. He has to appear with lawyer Mr. Devbroto Chakraborty Banerjee like this. We appeared. They are not looking none of them.
Mr. Idris, Muhammad Idris.
His lawyer came, Mr. Devbroto, something name. So, my lord, my humble submission, kindly allow me to contest this suit. So, Honorable Court, after hearing all the parties and whatever will come, I will obey it. But let me have the justice, my lord. This is my folded hand, this is my humble submission.
Please take down.
My lord, I am for Muhammad Idris.
Yes. What is your submission in this matter?
Yes, sir.
Devbroto Chakraborty.
My lord, he has prepared one affidavit. As far as I recollect, I also settled that draft. When facts emerged that after filing the writ petition, when at the time of filing the writ petition, the finality did not come, whom the tender was awarded. Subsequent to filing this writ petition, the information came that this tender was awarded to the private respondent. Accordingly, Muhammad Idris advised that it should not be brought to the notice of the court by bringing by a supplemented affidavit. Instead, it will be prudent to file a fresh writ petition, because prayers will be different. Because I have to seek setting aside of that order which has been issued subsequent to filing.
Challenge the appointment of the private.
That is the impugned order changed completely. That cannot be brought within the scope of the prayers unless I amend it. So there are two options: by filing an amendment application
or to file a fresh
filing afresh. Now, amendment is, my lord understands that it will be a complicated procedure.
Yes, yes.
Change
the nature and
yes,
character of
change the nature and character, and it may not be allowed or it may be allowed. So it was prudent. With my advice, I was senior, and he was the advocate on record. He asked me, and I gave. This was very informal thing, and I think it was prudent. So this is the position, and accordingly, Muhammad Idris spent a lot of money to prepare the writ petition afresh, and thereafter he is getting this view from the client that it was not done as per their opinion, as per their instruction, which is, my lord, I am leaving the matter to your lordship. So as a lawyer, he did the correct thing, in my opinion.
Okay, my lord, in this regard,
I leave it to your lordship, and he is a cancer survivor, my lord. He is in.
I understand.
My lord, now this story I just came to
I
know.
shall file the affidavit.
No,
I have served.
I did not get any copy. No copy has been served to me. First. Second, this story is newly has come to me. But when the petitioner asked the erstwhile lawyer, Mr. Idris, what is the position of my case, that time he told that your case is going on. At that time, he is showing his copy from that side. This is the order of the court. This is already disposed of. How you are telling like this? I have not narrated, considering that he is a senior. That's why I did not narrate all this fact, because paying him, just showing him respect. Now I am getting the another story. Whatever it might be, sir, my humble submission before your honor, before your honorable court, that my case may kindly be allowed, my petition may kindly be allowed, my doubt can be restored.
Proceed with
for
your
having
way.
justice.
I have no objection. I have no.
Okay. Okay. Please take down. Can 1 of 2025. This is an application for recalling of order dated 26th of February 2025, passed by this court in WPA 2578 of 2025. Full stop. It is the contention of the petitioner that the petitioner was proceeding with this writ petition, but suddenly came to know that the writ petition was disposed of as not pressed on the instruction of the petitioner. Full stop. The writ petition was by such way this court has disposed of the writ petition on 26th of February 2025. It is the contention of the petitioner that she has not instructed his advocate on record to not press the writ petition by filing an application being Can 1 of 2025 through affidavit. The petitioner has apprised this court that the writ petition may be revived. Learned counsel appearing on behalf of the writ petitioner has also placed on record the judgment of Honorable Apex Court passed in Mahavir versus State of Haryana, passed in Criminal Appeal number 5560-5561 of 2024, wherein in paragraph 96 the Honorable Apex Court has held that clients should not be suffered due to misinstruction of the lawyer. The state has filed affidavit in opposition against the application being Can 1 of 2025 and contended that once the writ petition was not pressed at the instruction of the petitioner, the same writ petition cannot be revived by way of an application. The contention of the petitioner, the contention of the state respondent is that the petitioner cannot choose once to dispose of a writ petition and once and again to revive the same. Learned counsel appearing the application was served upon the learned advocate on record, Mr. Idris. Full stop. One representation is made before this court on behalf of learned senior advocate Mr. Idris through an affidavit. Are you preferring an affidavit?
Yes, sir.
Through an affidavit.
If my lord desires, I can submit.
Yes, you file it.
It is the last affidavit. Commissioner না ওটা হবে না নোটারিটা কই এটা হবে না চেঞ্জ হবে হ্যাঁ নোটারিটা এটা আমার ফাইলটা নিয়ে চলে আসছে
I did not get any copy, my lord.
No. Malad, today I am not getting.
Then forget it. Forget it. Have it? You
This
have
is
it?
Yes, this one. 17th July. Yes. Leave now, notary kora ache. Yes. Malad, I take leave because it has been notarized.
Okay. কি বললাম বলো? Affidavit, by an affidavit,
Notarized.
by an affidavit, through affidavit was shown, which the affidavit was shown before the notary public. Necessarily to accept the said notarial affidavit be taken on record. Full stop. It is the contention of learned senior counsel, Mr. Idris, that after considering the merit of this matter and subsequent events, Mr. Idris has advised it would be prudent for the petitioner to not press the writ petition and file a separate writ petition on the facts and prayer, on the basis of some facts and prayer which would be benefited for the petitioner. Full stop. On such instruction, on such advice, the junior of Mr. Idris has submitted before this court on 26th of February 2025 that the petitioner doesn't want to proceed further with the writ petition. However, the petitioner has changed his mind, so it is the statement of Mr. Idris that this court may take any decision as per desire of this court. Having heard the entire facts and circumstances, also considering the affidavit of state as well as the affidavit submitted by on behalf of Mr. Idris, erstwhile learned advocate on record, it appears that the order passed by this court on 26th of February 2025 is under the instruction of the petitioner. Full stop. Being an advocate on record, Mr. Idris has advised to not press the writ petition. However, such advice appears to be not satisfactory later on to the petitioner. Thus, the instant application has been filed. Having heard the entire circumstances and considering the fact that the petitioner was not in intention to proceed with the matter, thus I think is necessary matter, and the affidavit was made on behalf of the petitioner before this court. So this court has to accept the affidavit of the petitioner. Accordingly, I think it necessary that the application being Can 1 of 2025 should be allowed. Let the application for recalling of order dated 26th of February 2025 is considered and allowed. Full stop. The interim, the order dated 26th of February 2025 is hereby recalled. Full stop. The order of disposal of the instant writ petition being WPA 2578 of 2025 is hereby set aside. Full stop. The WPA 2578 of 2025 he revived
I will tell you the motion state.
Motion is in its original number. Full stop. The petitioner is directed to serve upon the respondents regarding the revival of the writ petition. Full stop. Revival of the writ petition, file an affidavit of service. File an affidavit of service to this court. Let the matter go out of the list. Parties are at liberty.
Should I appear on behalf of the state? The service will be
Why
done
not kindly allow
directly.
me to give me direction to change the address. Little mistake is there. Post office. Raiganj, in that place it will be Raiganj. It is written Konojoda. It will be Raiganj.
That, not like that. You have revived it. It was revived and you serve.
Service will be done directly to the advocates or when not already appeared.
In leave of my learned senior friend, may I pay this matter? Mohammed Idris was the advocate on record. Since there is no objection is there, it is revival. Kindly record that he is permitted to retire from the brief. Otherwise, there will be difficulty for no objection for my learned friend.
Okay. Mr. Idris, Mohammed Idris, learned advocate on record, appeared on behalf of the petitioner, wishes to retire from the brief. Full stop. Let the submission on behalf of Mr. Idris be accepted.
Can
dispose of.
This name of the advocate.
It will appear automatically.
Okay. All right.
It will appear automatically.
My lord,
Next.
my lord, apologies, my lord. I couldn't reach till my item was called item number 15. I'm led by Mr. Pratip Kumar Chatterjee, Senior Counsel, my lord. My lord, he will be out of station the next week, and it is being fixed on Monday, my lord. Kindly fix it on 26th, my lord. Before that, he is unable to appear before your lordship.
25, 15.
15.
What do you want? 26.
As the convenient of the court.
26.
26, my lord.
Item number 15, 26.
Grateful, my lord. Grateful.
Call the list.
25, my lord, I am for.
Yes.
25, my lord, I am for the petitioner.
My lord, I am appearing on behalf of the opposite party.
My lord, this is the second round of litigation, my lord, in this respect, my lord. What has happened, my lord, is my lord, in a suit for eviction, I am the defendant.
What is the order under challenge?
My lord, I'll just indicate.
Order dated 25th of April 2025.
My lord, 25th of April 2025 order, my lord. The certified copy your lordship, my lord, will get at the last,
Yes.
end, my lord.
What is the order? Who are you? You are the
I'm the defendant in the suit.
defendant in the suit.
In the suit.
Defendant, tenant.
Tenant.
Trespasser. My lord, trespasser.
For eviction, my lord, my stand
for eviction by the
my lord,
plaintiff.
by the plaintiff. My lord, my stand is, my lord, I'm not a tenant, my lord, I'm a licensee.
Tenant, this is my lord, trespasser. The suit.
My lord, my stand, my lord, my stand is I'm a licensee in the suit below, my lord. My lord, whatever be that, my lord, be that as it may, my lord. My lord, I'll just indicate, my lord. Be that as it may, my lord, this relates to, my lord, an order, my lord, an application made on by them, my lord, by the plaintiff. The sole plaintiff died. My lord, they have, my lord, made a substitution, setting aside abatement application. It was after a substantial delay, the application was made. Now, my lord, I have taken, my lord, two full stand, my lord, during, my lord, the application stage. My lord, there was evidence while, my lord, the application was being taken up, my lord. It was registered as a, my lord, miscellaneous case. My lord, during the evidence stage, my lord, they initially, my lord, produced a Xerox copy, my lord, of a death certificate of one of the, my lord, the legal heirs of the original plaintiff. My lord, our stand, my lord, at that point of time, my lord, our stand was that, my lord, a Xerox copy has to be admitted only after, my lord, proper procedures for secondary evidence is being followed up. Otherwise, my lord, a Xerox copy, my lord, suddenly a production of a Xerox copy and that is being admitted, my lord, that is being admitted by the learned court, my lord, this is not the procedure. They have to satisfy whether the original document is not, why the original document is not there, why they are applying for the Xerox. My lord, section, your lordship knows, my lord, better than any of us, my lord, section 65 of the Evidence Act, my lord, that procedure is to be followed. Now, my lord, since initially, my lord, I was able to obtain an interim order, my lord, from this honorable court, my lord, in the proceeding. After that, my lord, the matter came up for final hearing, very recently, my lord. Lordship, my lord, will get the order, my lord, at page 80. 25th June, my lord, the matter was finally disposed of. My revisional application. And my lord, his lordship, my lord.
Order dated 25th of April.
That is the impugned order. My lord, I am, my lord, referring now, my lord, to the order of this honorable court, my lord, while disposing of my previous revisional application. Page 80, my lord. Page 80, order dated is 25th of June.
Another CO.
Another CO, my lord. The previous round of litigation, my lord, where I, my lord, challenged the acceptance of a Xerox copy of a death certificate without, my lord, following the proper procedure of section 65.
Happened there?
My lord, his lordship, my lord, was of the view, my lord, kindly sees, my lord, I am placing, my lord, from paragraph number 2.
Yes.
Learned counsel for the petitioner submitted that the exhibition of document is in contravention of section 63 and 65 of the Indian Evidence Act. Learned counsel submits that photocopy of death certificate has been exhibited by the learned trial court without any explanation being offered by the party producing the document. At the outset, the court considers that there is no substance in the case of the petition. It is a settled proposition that mere exhibition of document does not ipso facto means proof of the document in accordance with the provision of Indian Evidence Act. It is repeatedly been held that exhibition of document at the stage of evidence is merely for the purpose of identification. The court at the time of final determination is required to examine the authenticity, admissibility, and evidentiary value of the said document in accordance with the provisions of Indian Evidence Act. Even the learned trial court has, my lord, correctly stated that the document does not ipso facto sanctify a case of the petitioner and he has to prove his case on merits. Thereafter, my lord, the learned court, the honorable court, my lord, further holds the court considers that the petition has no substance as there is no illegality or perversity in the order. However, the petitioner is given liberty to raise all objections regarding admissibility and of the document at the time of final determination of the issue. Therefore, my lord, I was, my lord, directed to canvass my case before the learned trial court during, my lord, the final argument. Now, my lord, after that, my lord, I went back. My lord, there has been, my lord, one difficulty, my lord, I'll indicate. My lord, now, my lord, kindly takes up the 25th April order.
Yes.
My lord, this order has been, my lord, the previous order, my lord, of this honorable court, my lord, was passed in June. This order was communicated. It was, my lord, after that, my lord, it came to the notice, my lord, that 25th April, my lord, the miscase has already been, my lord, disposed of without taking into consideration, my lord, two aspects. The only consideration of this order was there was a delay of, my lord, 375 days on odd, my lord. The only consideration in the application was whether the delay was justified, and the delay, the learned trial court has went on to, my lord, state that the delay is justified, and mechanically, my lord, allowed this application under, my lord, order 22 rule 4. Now, my lord, kindly considers, even without, my lord, going into the evidentiary value of that particular death certificate, my lord, another aspect, my lord, was, my lord, pointed out by me. The learned trial court, my lord, does not say anything regarding that, my lord, and that is a serious allegation, my lord, that I have made. Kindly, my lord, takes up my written objection in the order 22 rule 4. Lordship kindly takes up page 68. Page 68, my application, my objection starts. Page 69, I'll place before your lordship.
Yes, which para?
Page 69, my lord, paragraph number 7. I state, my lord, that this application has been filed, my lord, by 4 persons, and they say that one of them is Deepali Ganguly. She has died. I, my lord, very much doubt that, and I've stated that you have only produced an application. You have only produced a Xerox copy of the death certificate, which is illegible, which is not proper in proper form. Irrespective of, my lord, be that as it may, kindly takes up paragraph number 7.
Where is your paragraph 7?
Well, paragraph number. Well, kindly, my lord, takes up paragraph 7 once. Well, page 69, paragraph number 7. I state that there is another legal heir whom they have failed to, my lord, bring into the records. Deliberately not brought into the records.
Okay.
Well, the learned, well, Shopna Das is one of the wife of Rajiv Das, is the youngest daughter of the deceased. That is on record, my lord. My objection is on record. And, my lord, my another fact is, my lord, that I was given an opportunity by this honorable court, my lord, to take all the points, my lord, regarding admissibility of that particular document regarding the death certificate of Deepali Ganguly. That chance was also gone.
You have not challenged this in the objection.
Lordship is, my lord.
Oh, you have challenged it in the at the time of making objections. Or,
Well,
but in the written objection, you have not stated that.
This one is my written objection, my lord. Page 68.
You have not stated this, that the death certificate is false. Or...
My lord, that was, my lord, put into cross-examination.
Okay.
At that point of time, it
That
was
is,
not available.
Yes, I want to know.
While filing the written objection, the fact that Deepali Ganguly died, that was, they did not state that. During cross-examination, a Xerox copy of the document was shown. So the death certificate of Deepali Ganguly, I say that is inadmissible. And moreover, they have suppressed that there is another legal heir. And everything is on record, my lord. My WO is on record. The learned trial court, my lord, does not hold anything on this. Goes on, my lord, to dispose of the miscase, considering that
They have stated there are 5 legal heirs of Haradhan.
Haradhan.
One of them, Deepali Ganguly.
Deepali Ganguly.
Deepali Ganguly expired during
They say they have expired.
During pendency of the proceeding.
During pendency, they say expired. Produced for.
They produced a death certificate, Xerox death certificate.
Xerox copy of the death certificate, which was, my lord, inadmissible and at the stage of.
You raise objection at the time of cross examination.
Yes.
So also you have stated a fact that one legal heir, Swapon Das, is missing.
Swapna Das.
Swapna Das. Swapna Das, wife of Rajiv Das, who is the younger daughter of the deceased Haradhan Das. She was not incorporated.
She was not incorporated.
Very good.
But the learned trial court, my lord, needs to, my lord. Sorry, the learned trial court, my lord, needs to, my lord, go into, my lord, at least take into consideration, my lord, this aspect, my lord. My lord, the evidence was closed, and, my lord, the final argument stage, my lord, I could not participate since, my lord, the revisional application was pending here in, my lord. Even, my lord, at the stage of
You are
DW.
not there?
Yes, my lord.
You are there? No, you are
The
not there.
respondent has also claimed the submissions.
My lord, I was present
The
throughout.
respondent has submitted
Okay,
the
okay,
objection. Objection. My lord, this is not a suit for declaration of my lord, the ownership. There is no dispute regarding ownership. My lord, this is a plain suit of eviction of by the trespasser. My lord, that initially in this case, my lord, the main suit, my lord, the file in 1981. My lord, eviction suit. Eviction suit court decreed. My lord, the execution court believed, my lord, giving possession. After satisfying the decree, well, then again, my lord, the tenant, my lord, the forcibly occupy the property. Then, my lord, this suit is filed for eviction by trespasser. My lord, as per 116 of the Evidence Act, well, if there is any dispute regarding title, my lord, he has no right. My lord, only for eviction, my lord, one co-sharer is sufficient for continuing the suit. My lord, this is a very simple eviction suit.
No, Haradhan Das is the.
Haradhan Das is my father. The father is the landlord. After death of my father, the brothers and the mother and sisters, all are the married daughter, something. But this is a simple suit, and the title, there is no dispute regarding title or ownership of the property. You are the trespasser, simple trespasser. Well, then as per 116 of the Evidence Act, but even if 116, he has no right to raise objection regarding title. Who is the owner of the property, file a suit. Only he is a tenant.
No, that is not the issue. Issue is that whether you have made all the legal years in the.
But in all legal years, kindly see the objection. All the submission kindly see. The respondent submit written objection stating section 5, only 5 point is limitation act is not maintainable at the present form. There is a, as per abatement of the suit as such, section 5 is not liable to dismiss. Respondent further plea taken a petition misconceived, misleading the respondent stated written averment made in application section 5 is frivolous, and the respondent claimed the petitioner following document exhibit the on death certificate of Haradhan, on death certificate of Sumitra Das, and death certificate of Dipali Ganguly has been marked exhibit with a strong objection, and Samsundar Das and the examined. But only point is that Dipali Ganguly is marked as exhibit. Only that point is raised. Kindly see, this is the point raised.
Now, what about the legal?
There is no. There is no
left out.
Left out. There is no question. There is no question submission by the respondent.
No such legal left
out.
out.
No legal left out. And also, kindly see the order. There's a only abatement that is hereby allowed, and the suit is fixed for original form from the other side. He has liberty already always given to contest the suit.
Yes.
Well reasoned order passed by the learned judge.
Kindly considers, my lord, the order itself, my lord. There is delay of 63 days.
Yes.
My lord, that is, my lord, allowed without any particular, my lord, explanation, my lord, citing of judgments, and my lord, rest of my objection is untouched. my lord, the court does not come to a conclusion that my averments are wrong, his statements are correct. All these facts are absolutely untouched. My lord, my objection is on record. That needs to be considered. If it is disallowed, disallowed.
That's all.
And my lord, kindly considers one aspect, my lord. After my lord, this honorable court's order, my lord, that my lord, at final hearing of this my lord, I came up in connection with the misapplication. My lord, the page number 81, my lord, I'm referring to, my lord. Page 81, paragraph number 4. From the however portion, my lord. My lord, I came up, my lord, against the my lord, the proceedings of the miscellaneous case. My lord, the main suit is, my lord, that was, my lord, not considered before this honorable court, my lord. My lord, specific, my lord, liberty was given to me, my lord, to take this point, my lord, during the final argument stage, my lord. The difficulty was, my lord, that final argument, my lord, already had, my lord, the court had already closed the final argument by that time.
How?
My lord,
Order speaks that you have.
My lord, this is 25th of June. My lord, this order, my lord, page 80 order. Page 80 order, my lord, is of 25th of June.
Yes.
And my lord, kindly considers, my lord, the order, my lord, the impugned order. This is 25th of April. Both party appear. My lord, the honorable court comes to the kind of findings, my lord, that I am, my lord, entitled to take this point during the final argument of the misapplication, the miscase.
5th of June, the order of CO has been passed.
Passed.
And 25th of April, the final order was passed.
Final order was
So why the matter is there? It was heard on the, yes, it was passed in the open court. Why would not mention this?
At that point of time, my lord, it was, my lord, unknown to us. That was this fact was unknown to us, my lord. While the order was communicated, my lord, the fact came that
yes,
already, my lord, the misapplication.
You must have communicated this court that the final order has been.
This was, my lord, this fact was unknown to us at that point of time.
Then how can I decide?
But my lord, kindly considers, my lord, without an opportunity, my lord, kindly considers, my lord, the order on its merit itself. Kindly, my lord, kindly considers the order independently on its merit, then, my lord.
How can this? You have received this order. The order has been passed without informing the court that the final order has already been passed on 25th of April.
My lord, even if, my lord, I forego my liberty, my lord, kindly considers, my lord, this order independently on its merit. This 25th of April order on its merit. My lord, today, my lord, I am challenging before your lordship this 25th of April order.
Very good.
My lord, kindly considers this on its merit, my lord. My written objection, my lord, specific averment was there. And my lord, with regard to, my lord, the other points, my lord, the limitation also, my lord, the court does not hold anything specific. Judgments have been, my lord, few judgments. My lord, a delay of 463 days, that has been condoned, my lord, without any averment itself. And my lord, with regard to, my lord, my written objection, my lord, paragraph number 7, what I, my lord, just shown your lordship, my lord, the court, my lord, does not, my lord, comes to a particular finding.
Okay. Please take down. Instant CO. Instant civil revision has been preferred against order dated 25th of April 2025, passed by learned Civil Judge Junior Division 4th Court Sirampur Hubli in Miss Case number 52 of 2018, within bracket arising out of TS 45 of 2016, bracket close. Next, learned counsel for the petition submit that the impugned order passed by the learned trial court is erroneous. Full stop. It is the contention of the petitioner that the learned trial court has abruptly condoned the delay of 463 days without assigning any reason. Stop. Moreover, the objections raised by the present petitioner, OP, present petitioner, bracket OP before the learned trial court, was not considered properly. Full stop. It has also submitted on behalf of the petitioner that the petitioner has approached this court on the earlier occasion, challenging the challenging the order of the court, order of the trial court dated 4th March 2023, whereby the learned trial court has exhibited a Xerox copy of death certificate of one legal heirs of the plaintiff, namely Deepali Ganguly. This court, while disposing of the said CO, has directed the petitioner stroke opposite party before the learned trial court to raise the issue at the time of final hearing. It is the contention of the petitioner that the learned court below, learned trial court, has not considered the objection of the petitioner. The order has already been materialized, the final order has already been materialized before the order of this court was passed in the earlier litigation. We further pointed out that the order is perverse and required to be set aside. Learned counsel appearing on behalf of the opposite parties, stroke plaintiff before the learned court below, submit that the order is perfectly correct and reasoned order. There is no scope to interfere. He further submits that this court has disposed of an application for abatement of sent aside. This court has this learned trial court has disposed of an application for setting aside abatement preferred by the legal heirs of erstwhile plaintiff. Full stop. The learned court below, after considering the entire evidence on record, has allowed the said application within bracket miss case 52 of 2018, and thereby the original suit be revived to its original file and number after setting aside abatement. He further submits that there is no illegality or impropriety in the order. Having heard the learned counsel for the parties, it appears that in the earlier litigation, the present petitioner has approached this court challenging the order passed by the learned trial court, whereby the learned trial court has accepted a Xerox copy of death certificate of one of the heirs of the plaintiff. It was the contention before the learned court below on the it is the contention before it is the contention of the petitioner on the earlier litigation that the said death certificate cannot be accepted in terms of the provisions of 63/64 of Evidence Act. This court this court disposed of the said civil revision on 25th of June 2025, when the instant order under challenge has already been passed on 25th of April 2025. However, the petitioner has not disclosed before a coordinate bench of this court regarding the disposal of the entire miss case. Thus, the objection regarding the scope which was given to the petitioner to raise the objection by passing an order dated 25 of June 2025 cannot be availed as the final order has already been passed on 25th of April 2025. In considering the other merits of this matter, it appears that this court has condoned the delay of 463 days on the ground that the petitioners are the laymen. The learned trial court has also followed the decision of Honorable Apex Court in Mithailal Dal Sangar Singh versus Anna Bhai Devaram Kini. They can ask. 2003 10 SCC 691. And allowed the application under Section 5 of Limitation Act by condoning the delay in filing the substitution application. Full stop. It appears that next paragraph, the true nature of determination of Section 5 of Limitation Act is that the petitioner has to disclose a sufficient reason. Full stop. Consideration of sufficient reason in each and particular case is different. There may be separate set of facts to apprise a court regarding the condonation of delay and the sufficient cause. Full stop. The consideration of the court in considering an application under Section 5 of Limitation Act, that is to determine whether the sufficient cause has been assigned by the petitioner, is purely a discretion of the court which is who is hearing the application. Full stop. In the impugned order, this court has satisfied, trial court has satisfied that the petitioner were layman and unaware about the legal system. Thus, the cause shown to the learned trial court appears to him to be sufficient. The discretion as exercised by the learned trial court appears to me justified and legal. He has also placed reliance upon an order of Honorable Apex Court. Thus, in that score, I find no infirmity in the impugned order. Full stop. Next para. A serious question was raised by the learned counsel for the petitioner that at the time of filing written objection, he has stated a name of legal heirs of deceased plaintiff who was left out. Full stop. It is the contention of the petitioner that this matter was not considered by the court, by the learned trial court at the time of passing the order. Full stop. It appears to me that in the entire order, the learned trial court has not mentioned the objection of the petitioner regarding the left out legal heirs. However, the scope of the petitioner was always there before the learned trial court to raise the objection of non-joinder and misjoinder parties in the suit itself. The suit has only been revived, and the opposite parties, the petitioner, that is the opposite party, that is the defendant before the learned court below, has every scope to raise such objection of non-joinder and misjoinder parties, which can only be decided at the time of hearing, at the time of final hearing of the suit. Thus, at this juncture, I find no justification to entertain the petitioner. Hence, the instant civil revisional application be disposed of.
My lord, kindly only one aspect, my lord, may I point out? My lord, the suit was at the DW stage, now it's at the judgment stage. Therefore, my lord, to take the point of misjoinder, my lord, during the
Petitioner stroke defendant be at liberty to raise the point of non-joinder and misjoinder parties by filing supplementary by filing subsequent pleadings as per provisions subsequent pleadings on such the subsequent pleading such subsequent pleading must be filed before the court only on the point of law on or before 3 weeks from the date of passing of the order. The petitioner, the plaintiff is at leave to file an amended on such filing of the কি বললাম কাটো the learned trial court shall dispose of the application for subsequent pleading according to the law.
grateful.
Next.
Caveat আছে তো
And for the
Which for the opposite party?
Not
there is caveat absent.
Caveat absent. Lord, what happened, my lord? I am the defendant in the suit. The plaintiff filed an application, my lord, for amendment of plaint. Now, my lord, kindly see.
You are the defendant.
I am the defendant. Kindly see, my lord, the cause title of the plaint at page 8. Who are the parties? Kindly see the name Srimati Paramita Mondal, wife of Snehangshu Mondal. And my lord, versus Pranab Datta is my client. Now, my lord, in connection with the said suit, the plaintiff, my lord, had filed an application for amendment of plaint. My lord, kindly see what is the amendment. Kindly comes to, my lord, page 20, the application for amendment.
Yes.
Kindly see, my lord, this is an application praying for amendment of plaint filed by the plaintiff. Kindly see at the bottom, my lord, kindly see who is signing. Signing is one Paramita Datta. She is not the plaintiff. She is not the plaintiff. Kindly see, my lord. In every page at the bottom, kindly see who is signing Paramita Datta. Every page. Even, my lord, kindly see page 30. Kindly see, this is the affidavit portion. I, Paramita Mondal, such and such, such and such. So he is affirming the affidavit, page 30. Paramita Mondal. Kindly see at the bottom. Yes, at the top, my lord. Kindly see I, Paramita Mondal. At the top, page 30. At the top, in the type portion, he is saying I am Paramita Mondal. At the bottom, my lord, kindly see before deponent, right hand side bottom,
Paramita
Datta, and the advocate is identifying him. Now, my lord, we filed an application before the learned trial court, which is at page, my lord, 45. Kindly see what is the application.
that on 7th May 2024 at the belated stage, a copy of the application purportedly under Order 6 Rule 713 was served upon the petitioner's learned advocate Shri Amitabh Basu, fancifully praying for amendment of plaint on such alleged grounds bearing the forged signature of the plaintiff, which is apparent on the face of record itself, and it will reveal on carefully perusal of the same that someone has signed in the name of the plaintiff as Paromita Mondol in each page of the application, including that of the affidavit, and the same was identified by one advocate Sri Tirthankar De or Das as it could be bearing registration number such and such, and one notary public is P. Basu at Alipur Judges Court has affirmed the said affidavit. The purported document being the forged signature of the plaintiff has been filed before the learned court, which itself a clear case of forgery and tantamount to criminal offence, and the defendant reserves his right to file separate application before the learned court for keeping the said petition in the safe custody of the learned court under the seal and cover of by taking out the same from the record, and thereby directing the plaintiff to appear before the learned court in person and to put the signature before the learned court in open court, and the said signature of the plaintiff along with the signature appearing in the impugned document, which is the said application, should be sent to handwriting expert for comparison and for filing report to the effect, so that the defendant could take appropriate legal step in accordance with law, and to urge before the learned court to initiate proceedings for forgery by drawing up proceedings under section 340 of IPC, referring the matter to the learned magistrate at Alipur. And accordingly, it will be curious to and surprised to note that extreme audacity of the person who would dare to practice such fraud on the learned court by putting forged signature on the name of the plaintiff affidavit. This is Millard application. Millard, kindly see page 47. What is the prayer for taking the application from the record and to keep it in the safe custody? That is the Millard. This application was filed by my client. Now, Millard, this has been Millard. Millard, kindly see, Millard, at page 49, they have filed a written objection to this. This is very necessary. Millard, kindly see, Millard, page 50, paragraph 5. Yes, kindly see paragraph 5(1). Around the time when the petition for production of documents by the police authorities was being heard by the plaintiff, had sought for the opinion of a learned advocate, and accordingly she was advised to file a petition under Order 6 Rule 17 of the court praying for amendment of the plaint. Such petition was duly prepared by the plaintiff's advocate on record, Mr. Tirthankar Das. My lord has seen Tirthankar Das has affirmed that affidavit advocate. Then, Miller, kindly see number 3. During the said time, Mr. Das was entrusted with drafting of another petition of one Paromita Dotto, which he did. The said learned advocate had directed his clerk to take printout of both the petitions, that is Paromita Dotto as well as the petition of the plaintiff, and get them signed by respective clients. The said clerk of the learned advocate had mixed both the petition and ultimately got the petition of Paromita Mondol signed by Paromita Dotto. This is their explanation. Now, Millard, 2 or 3 things. Millard, the lady, Millard, who is signing, Millard, she is not illiterate. She has read the affidavit, every page. Millard, she is taking steps herself in the suit from the very beginning. Millard, had Millard this advocate Tirthankar Das Millard, or they Millard had another client called Paromita Dotto, Millard, that document ought to have been produced before the learned trial court for to prove that this is the correct contention. That was never done. Now, Millard, and this said Millard advocate Millard also identifies him as Paromita Mondol. Millard, now Millard, this application Millard has been our application has been rejected, Millard, and the learned trial judge Millard has accepted the contention of the opposite party that the papers were mixed by the advocate's clerk, and that's why Millard, I'm not entitled, not keeping it.
Where is the impugned order?
Millard, it's 23rd June 2025, last 3 pages of your lordship's brief.
Yes, they have admitted there is a bona fide mistake.
No, their admission, my lord, therefore, my lord, that said.
Objection is correct. They have admitted, but they had no intention to defraud the
No,
court
no,
like that.
definitely. Then, Millard, that advocate, the learned trial court ought to have been, Millard, directed that yes, you have another client or another matter by the name of Paromita Dotto that has to be produced. How do we know that that is only putting the blame on the advocate and his clerk and doing this? Ultimately, Millard, the plaintiff did not sign it. Millard, whether the learned trial judge or Millard was justified in Millard allowing this, Millard, in this way. Then the learned trial judge ought to have directed that said advocate Millard to produce that brief of the Paromita Dotto, which the learned advocate Tirthankar De is saying.
Learned trial court has believed the advocate. He has admitted his guilt.
Believe Millard, how Millard?
Yes, he has believed. He has placing the petition that I have signed the petition and left it for the.
Then Millard, no, he says
for the law.
Yes,
law clerk signed it.
No, then Millard, there is another Millard. Millard, if law clerk has signed Millard, then Millard, it is some
law clerk take the petition to the clients and they sign it.
No, then they said that it has to be affirmed also.
Yes.
Kindly see. Affidavit portion, kindly see. Advocate is not affirming it.
Very good.
Kindly see, Millard, page 5, Millard, 40, the amendment application. Kindly see again. Page 30. Kindly see page 30. Kindly see, Millard, the Paromita Dotto, Millard Mondol, he is signing as Paromita Dotto. Millard, he has read this. The notary public, Millard also must have checked it.
Yes.
The Millard, I do not know whether Millard, without asking the said advocate to produce the documents of Paromita Dotto, whether this application could have been allowed.
That's all. This is the grievance here. What is the order? What is the observation?
The observation is whatever is written in the impugned order, that has been accepted. That is. No.
That is not the intention of he to
Is there any order regarding fate of the amendment application?
No, this is pending.
How can it be pending?
Yes,
That should be dismissed. Amendment application should be dismissed. Is there any observation regarding amendment application?
Not that may not.
No, in the order impugned itself.
No
such. So if they take the
pending,
how can it be pending?
This is still pending.
How can it be pending? When they accept that this is the false, this is not the signature of the plaintiff, that should be dismissed.
It should go. It should go.
Very good.
And Millard, this Millard caveator has been lodged, Millard, kindly see Millard by the same advocate Tirthankar Das, and Millard, he is conducting the proceedings. I have served upon him. Same advocate.
Okay. Please take down. Instance civil revision has been prepared against an order dated 23rd of June 2025, passed by learned civil judge senior division 10th court Alipur, district south 24 Parganas in Manishu, 15 of 2014. The brief fact of the matter is that during the pendency of the suit, the plaintiff, namely Timothy Paromita Mondol, filed an application for amendment under Order 6 Rule 17 CP3. In the said application from page 1 to the last page. To the last page, the name of the signature of the deponent appears to be Paramita Dotto, PUTTA. In the affidavit portion of the said application, name of the plaintiff is appearing as Paramita Mondol. Full stop.
24 ছিল না 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 খাজা ওইটা
Present petitioner being the defendant, after receiving such application, has filed an application before the learned trial court under section 151 CPC, contending inter alia that the application for amendment under order 6 rule 17 was not filed by the plaintiff, and the plaintiff's signature was forged, which tantamounts to a criminal offense. The defendant intend to initiate a proceeding under section 140 IPC, proceeding of perjury under section 340 of IPC, and prayed that the document that the petition under order 6 rule 17 be kept in the safe custody to justify the forged and false signature of the plaintiff. Full stop. And a written objection was filed on behalf of the plaintiff against the petition filed by the defendant stroke petitioner hearing, wherein the plaintiff through affidavit has contended that the signature appearing in the application under order 6 rule 17 is signature of another person. Namely Paramita Dotto. It is contended in the said objection that learned advocate Mr. Tirthankar Das had another client, namely Mr. Paramita Dotto, and on the same day, both the clients, that is the plaintiff and Paramita Dotto, appeared before the learned advocate for swearing affidavit. The clerk of the said advocate had mixed up both the petitions, and ultimately application under order 6 rule 17 was signed by one Paramita Dotto. Full stop. By filing the objection, the plaintiff has unequivocally stated that there is a mistake on the part of the learned advocate. So the plaintiff prayed for dismissal of the application under 151 CPC. Learned trial court, after hearing both the parties, has observed that the learned advocate on behalf of the plaintiff admitted that inadvertently the petition was signed by one Paramita Dotto, being another client of the advocate. Full stop. The learned court, by passing the impugn order, has accepted the submission and rejected the application under section 151 CPC filed by the defendant stroke petition hearing. Full stop. learned counsel appearing on behalf of the petitioner submits that the impugned order passed by the learned court below is barbarous. The learned court below should have justified that there are that there is a presence of another person, namely Paramita Datto, of another person, namely Paramita Datto, who shown affidavit on the same day before the notary public. He further pointed out that learned court below has also not considered the act and action of the notary public, who abruptly admitted the swearing of Paramita Mondo in the signature of Paramita Datto. It is the contention of the petitioner that, it is the contention of the learned counsel for the petitioner that the learned court below has not assigned sufficient reason in passing the order. Thus, the impugned order is liable to be set aside. Next paragraph.
Junior is the advocate of
Caveat being caveat number, a caveat being caveat number 2811 of 2025. 2811 of 2025 was filed by the learned advocate by learned advocate Tirthankar Das, who was served before hearing of this matter. The service of the learned advocate Tirthankar Das be kept on record. Full stop. In spite of service, none appears on behalf of the opposite party. It appears that the learned court below has passed the impugned order whereby he accepted the contention of the petitioner as well as the explanation of learned advocate Mr. Tirthankar Das appearing on behalf of the petitioner. Full stop. The learned court below has affirmed that learned court below, after hearing the parties, has considered the view of the plaintiff that the signature of the plaintiff was not forged. It has further averted that due to the similarity in the first name of the parties, first name of the clients, the affidavits are mixed and duly notarized by the notary public. Full stop. By the notary public. He has also abated that learned advocate has put his signature in haste. Thus, such error could not be detected. On perusal of the impugned order passed by the learned trial court, it appears to me that the learned trial court has correctly accepted the view of the petitioner, view of the plaintiff, who by filing a affidavit has categorically stated that it is not the signature of the plaintiff, but is the signature of another person, namely Paramita Datto. Full stop. The learned court below has correctly accepted the submission of the learned advocate. So the objection raised by the present petitioner regarding forgery of signature of the petitioner appears to me not a good ground to accept. Full stop. On that score, I find no justification to entertain the petitioner. The reasoning of the learned court below in passing the impugned order appears to be justified. However, it appears that when the learned court below has accepted the contention of the petitioner, contention of the plaintiff, that the signature and affidavit as well as the verification made by another person than the plaintiff, thus the application under order 6 rule 17 should not be allowed to be continued. The learned court below has committed error or not by not disposing of the application under order 6 rule 17 CPC. Underscore, the order passed by the learned court below appears to me erroneous on that point of view. Under the above observation, the instant civil revision be disposed of with a direction, with an order that the application being order 6 rule 17 CPC filed by the plaintiff, which is now pending, which as per instruction of the learned counsel for the petitioner, is pending before the learned court below, is cannot be allowed to be continued, which was affirmed by another person than the plaintiff. Accordingly, the application under order 6 rule 17 pending to be determined before the learned trial court is hereby dismissed. Full stop.
However,
Let a copy of this order be served upon the learned trial court through the registry.
My lord would kind enough to record that in spite of service upon the caveat and none appears.
Yes, none appears.
Kindly, my lord.
I have recorded.
Oh, great.
Despite service, none appears.
Item number 24, my lord. I was 22, my lord. I was running
24,
down.
I have
22. But I was in that building. I was running, but it has been already
22. Who is for the OP?
party appeared, but
Call and just pass it over.
Lord,
Let OP come, otherwise it will be difficult.
otherwise on Monday.
It will appear on Monday in the same list.
In the same position, my
In
lord.
the same position.
Great. I'm grateful.
Call the list, mention matter.
Last occasion, Lordship, petitioners sought for a leave to withdraw the instant writ petition. This liberty to file the afresh on the same cause of action. Lordship was directed to file an application to that effect. That application was filed today, Lordship.
I want written instruction, not application.
It has been filed in terms of applications, Lordship, and it is filed.
Not necessary to file an application. I just want a written instruction.
Actually,
the situation going otherwise in this case, in this court.
He was sought
One
for
instruction, yes, earlier matter.
Yes.
One instruction is there from the learned advocate. Thereafter, the client again came that no.
Withdrawn on the simply withdrawn, then instruction is sufficient. But here in the present case, the leave is required to file the same
I can
cause of
pass
action
the
on-
leave, but I want a written instruction. Whether you have filed the
It is filed today, Lordship.
Very
It's
good.
not with the week.
Monday,
Lordship, can it be taken on 25th? Next week, I have some difficulties.
next week. Okay.
25. No, next week I have some difficulties.
Let the matter appear in the list on 25th of
And the
August 2025.
and copy to let's get it.
Next.
আমাদের না
Yes, which for the petitioner? No one is there. Next. Pass over. Not today. Next. Next.
In item number 31, Lordship, I beg to appear on behalf of the petitioner.
Yes.
For the private in this matter, Lordship, I led by Mr. Sobosai Chatterjee. This is my affidavit of service, Lordship. I have served upon the state and also served upon the private respondent, Lordship. Yeah. In this matter, my lord, the petitioner is a contested candidate in terms of a vacancy notification, which was issued, Lordship will find for page number 41, that is annexure P2, Lordship, you'll find that one memo being number 395/SCFS/GTL/2024 that was issued on 29/5/2024.
Yes.
This vacancy notification has been issued. Now, in terms of the vacancy notification, my lord, the petitioner has applied in the selection process. Now, Lordship, I draw Lordship's kind attention that your Lordship will come to the part 2 at page 42. Lordship will find that there is some criteria has been mentioned that your Lordship will find from column C that minimum height of a godown should be such and such, and the plinth level of should be 0.3 meter, that is 1 feet from the road level or ground level. That has been mentioned. Now, Lordship will find from the part 3 of the notification that the following person entity shall not be eligible to apply for a license of FPS dealers, namely a person holding a license, 2, a member of local bodies, 3, a minor person of unsound mind, such and such a person convicted by the court under the EC Act. And kindly turn to page 43, Lordship. Lordship will find a minor person, unsound mind of such and such. Now, Lordship, kindly come to the column Roman 5, Lordship. A person holding a post in the establishment of any state government, central government, or any authority or body or institution of local self-government established or constituted by or under the Constitution or by any other law made by the Parliament or the state legislature or by notification issued or order made by the central government or a state government. Those are the criteria, Lordship, where the person, if he is a member of such, he shall not be eligible to get the license. Those are the criteria. Now, Lordship, the petitioner has applied for the license. Lordship will find for page number 45. That is the application of the petitioner, that is Sukanto Chanok, Lordship. He has made the application. Now, Lordship, if Lordship come to page number 46, Lordship will find that in subject of this application, Lordship, that one notification has been issued by the competent authority, that is the area inspector, who asked that on 7th January 2025, there will be a inspection in the shop room come go down. Now, Lordship, I have annexed the document regarding my property and that by whom I am shown as a go down, Lordship. That is in page 47. Now, Lordship, kindly come to page 58. That page 57 is the personal hearing, Lordship, that the petitioner was asked for the personal hearing, and page 58 is the document which is obtained from the official side that his candidature has been rejected. Now, the cause of action has been arose, Lordship. Subsequently, Lordship, the private respondent, where my landed senior friend is representing, Lordship, that is the respondent number 7, Subroto Ghosh. Lordship may recollect that yesterday one matter was taken up by your Lordship when the petitioner has, that private respondent has mentioned one matter, Lordship. Now, this person is herein, Lordship, the private respondent. Now, my candidature has been rejected and his candidature has been allowed. Now, Lordship, I can show to your Lordship that then after, Lordship, the petitioner has made a representative before the concerned authority to the district controller, that is on, Lordship, 15/5/2025, alleging some discrepancies regarding the selection process and the selection of the private respondent. Now, Lordship, kindly come to page number 60. That is also a representation before the district magistrate. And thereafter, Lordship, a representation on 19th May has been made before the subdivisional controller, alleging the selection process which has been taken place by the inspector. Now, Lordship, kindly come to the document which I have annexed, Lordship, that is in page number 64. That this person who has been selected as a eligible candidate, most eligible candidate, Lordship, he is a member of a local body, that is a cooperative societies, a elected body where the petitioner is a member. The respondent is a member, Lordship. I'm indicating in terms of the notification of him whether he can be considered as eligible or not, as he is a member of a local elected body. Now, Lordship, kindly, I have annexed the photographs at page 66. That is shown the go down, Lordship, and subsequently there is another representation has been made before the district magistrate, and it's also forwarded to the DC, ADM, and subdivisional controller. Your Lordship will find from page number 67, where it has been specifically mentioned that how this private respondent has obtained the managed to get the license by showing the go down without its pth level criteria has been fulfilled by his go down shop, which has been shown for getting the license. Now, I show to your Lordship with the geotag photograph, Lordship will find for page number 70 that the person who is appearing in the photograph, Lordship, it is the person respondent number 7 who has been selected by the concerned authority as the most suitable candidate and eligible candidate. I have the photographs with the geotag, Lordship, that has been captured on 28/5/2025 when the entire selection process has been completed. The inspection of the godown has already been taken place, and subsequently personal hearing also conducted. Now, this person when has been selected, when this the petitioner came to know that the pth level height has been shown wrongly, and by suppressing the material fact, he got the license, and we have objected the same, and we have made the complaint before the concerned authority. He took a bulldozer, took a JCB, and tried to dig the road, Lordship, to show the pth level will be fit to the as per the criteria, Lordship. That has been page 70, Lordship. Now, I am challenging the selection process, and I have prayed to take appropriate steps against the inspector who have been inspected and declared that person as eligible, Lordship. Now, state is a better position than what they have found.
Now, already your objection has been taken.
Yes, your Lordship. In other writ application, it has been taken.
Already conducted inquiry.
Yes, your Lordship.
And the report was placed before the authority.
Yes, your Lordship.
The authority will take steps.
Yes, your
So, what is the purpose now?
No, Lordship, when this writ petition was filed, this order was not there, Lordship. Yesterday, the order was passed, Lordship. I have also mentioned that there is another writ petition can be clubbed together and can be taken up together, Lordship. Now, my portion which has remained, my prayer portion which is remains, Lordship, against the inspector who have inspected and give the clean sheet, Lordship.
Against the inspector?
Inspector, Lordship. I made him as a party, Lordship. That respondent number 6, the area inspector, food and supply, Lordship, that person who have inspected, who have given the clean sheet, by whom instruction, Lordship, it has been shown that the pth level was adequate to get the license.
What is your prayer?
Kindly come to my prayer, Lordship. Prayer E, Lordship. That is in page 31, Lordship. A writ of and or in the nature of mandamus commending the respondent to not to give any effect of such and such in favor of the respondent. And kindly come to the next prayer, Lordship. Investigation agent and do steps against the respondent, Lordship.
There is no abatement against the any inspector.
No, I give the abatement, Lordship.
Nothing is there.
If my learned senior want to contradict to my abatement, Lordship, let him come with an affidavit in opposition, Lordship. I have taken the abatement.
You have not pleaded so.
I have pleaded.
What I shall deny.
Lordship, kindly come to page 10, 16, paragraph 16.
Respondent number 5, subdivisional controller.
Lordship. Subdivisional controller and the area inspector, who is the subdivisional controller and the area inspector, by whom, Lordship, this inspection has been.
Respondent number 6.
Yes, your Lordship, that is
So why you said respondent number 5?
That is a typographical error, Lordship, because I have paid against the respondent number.
Just one paragraph of the writ petition, if Lordship kindly take up. Paragraph 9, page 7.
That is in terms of the petitioner.
He's become satisfied about the inquiry. There is no allegation.
Paragraph 9, sir.
Yes, your statement. The petitioner states that during the course of such inquiry, members of the so he has no allegation against them.
That is for me. Your petitioner further state that.
That
is for
now, your Lordship, one paragraph I shall read from this petition. Kindly come to annexure P5. Before that, just one paragraph. But kindly turn to page 7, paragraph 5. Paragraph 9, just type it.
Yes.
Second paragraph. Photocopy of the relevant documents of the godown and its title and sketch map, along with bank solvency documents, are annexed herewith and marked with the letter P5. Now, kindly turn to page 47, P5. his document at page 47. Classification of the land, Jol. It is his document.
Thereafter converted.
My lord.
Thereafter converted.
And turn to page 48. Very next page. There is a conversion certificate.
পড়া যাচ্ছে না কিছু।
হ্যাঁ, আমারটাও কালো এসেছে কিন্তু ওটা বোঝা যাচ্ছে বাস্তু হয়ে গেছে।
বাস্তু কোন প্রপার্টিটা সেটা
ওই
দেখা
জবটাই
যাচ্ছে
বাস্তু
না।
হয়েছে conversion certificate।
It does not appear the description of the land, but it appears, well, kindly see.
Code number 240.
And there is no such allegation. License has been granted. Then let there be a direction for filing evidence.
Yes.
Let a direction be given to finance.
Please take down. Petitioner applied for license in terms of vacancy notification dated 29/5/2024, issued by SCFS Ghatal. Full stop. After his application accepted online, proposed shop-cum godown of the petitioner was inspected. It is the contention of the petitioner that the petitioner is a most suitable candidate, but the respondent authority has selected private respondent who is one of the member of local local what is it?
It's not Panchayat lordship. It's a cooperative society lordship.
Local cooperative society.
That's a bar. Even his submission.
I've raised this objection. It's not my
Local cooperative society. He also made several objections before the authority regarding the selection of private respondent. Full stop. He submits that the authority concerned, the private respondent has taken recourse to defraud the authority to have the license. He also made an amendment in the prayer that area inspector concerned is hand in glove with the petition.
But there is no such pleading in the writ petition.
Such pleading?
No pleading. Let you show your pleading. Let you show your pleading.
Page 10, 16, lordship. Page 10, paragraph 16.
16.
Where is that?
No, you have not.
Such and such by explained rejection, the petitioner made effort in inquiry.
No, against the
Against the inspector, where is that allegation? Specific
area
plead?
inspector. Oh, no.
Nothing.
Cut it. Full stop. He submits that the respondent authority has not considered the objections and issued license in favor of the private respondent. He prayed for necessary direction upon the respondent authority to
Affidavit, my lord.
cancel the license issued in favor of the private respondent. Having heard the learned counsel appearing on behalf of learned senior counsel, Mr. Devbrata Sahara, appearing on behalf of the
paragraph 21, lords. Paragraph
on behalf of the private respondent submits that the
page 11, paragraph 21, I have pleaded, lordship.
Submits that the after thorough inquiry, the respondent authority has issued license in favor of the petitioner, in favor of the private respondent. But due to the objection raised by the petitioner, allotment was not made. Due to the inaction of the respondent authority, the private respondent has also
client is
filed a writ petition which was disposed of by this court, directing the respondent authority to take decision. Full stop. Having heard the learned counsel for the despite what is the affidavit of service?
I have handed over, lordship.
Okay. Despite service none appears on due to state of having heard the submissions of the parties, it appears that the petition cannot be disposed of. Cannot be disposed without giving appropriate opportunity to the respondents to file affidavit in opposition. Let the affidavit in opposition be filed by the private respondent as well as the state respondent.
But 4 weeks time may be given, my lord.
Within 4 weeks from that. Reply, if any, by the petitioner within 2 weeks thereafter.
In the meantime, license shall be handed over to you.
License already handed over, but no further steps to be taken.
2 weeks.
But
As it is has been held in your lordship.
that will be contradictory to the order passed by your lordship yesterday.
Asking for any contradictory order. Lordship.
2 weeks.
Already to that
Let the matter go out of the list, parties are liberated.
My lord, my lord.
Further no allotment given.
That's the order passed by your lordship yesterday.
I have already passed out.
Covered by the
That will be contradictory.
lordship.
Go out of list.
Yes, okay.
Vote to go out of list. Now.
Next.
সেবার order হয়েছে। আমার উপর তো।
The petitioner is a widow. After the death of her husband, she was issued FPS license on compassionate ground. That is on 15 June 2020. Your lordship will find from annexure P1, page 28. Thereafter, Lord, petitioner had been running FPS business with number of ration cards, 4,800 without any count. Your lordship will find page 30, annexure P3.
Yes.
Thereafter, my lord, on 2nd November 2022, the termination letter was issued by the respondent authority to the petition without any proper inspection. Now, your lordship will find from annexure P4 that order, termination order, I have challenged by another writ petition which was pending before this honorable court. That writ petition came up before Honorable Justice Vivek Choudhury. The said writ petition was dismissed for default that I have annexed all the documents. I have filed restoration application. Matter is appearing before your lordship is at item number 71. During the pendency of this writ petition, Lord, they have issued new vacancy. Your lordship will find from annexure P9, page 42.5. In the same locality, they have issued. Where I have been running the said business. Your lordship, point 5, the application can be submitted on online mode only through the official website of the department. Please visit the website of the department such as apply for new FPS license. That order notice issued by the concerned authority, I have challenged in this petition. That I am praying not to give any effect till the disposal of the writ petition which I have challenged.
Oh, what is your status now? How can you challenge this?
My lord,
Your license has already been terminated.
but I have been terminated.
Then?
Well, that's why, my lord, I have challenged the termination notice by filing another writ petition. That writ petition is pending.
There's no stay at all, my lord, these petitions.
So in that writ petition, you may file an application like that. Why the new writ petition?
So, in the meantime, they will have filled up the vacancy because new vacancy.
If I consider the present writ petition,
let them file affidavit, my lord. I have been
present writ petition, you are nowhere. You don't have any right now.
I have been, my lord, they have not made any proper inspection, my lord.
You
That's
challenge your termination order in a writ petition.
Yes, my lord.
You have
That is a separate cause of action.
there,
Yes, my lord.
but not by fresh writ.
But I have not, my lord, I am not on this one. I am, my lord, only I am not submitting to your lordship that they have issued new vacancy, my lord, in the same locality, my lord.
Because your license is terminated. That's why new vacancy.
I have not been given
Not resultant.
That writ petition is pending, my lord, before this honor.
Not writ petition.
But
This is
that's
for
what you-
default. That was this is for.
Yes, that not in bond, it is not even bond, my lord.
Then it was not revived yet.
Yes.
That matter is accepted. That petition dismissed, but I have disclosed in this writ petition. I have filed restoration application. That matter is appearing, your lordship, please.
Now, in considering your application now, in the present writ petition,
Yes.
what is your status? How you aggrieved?
But I have been, because, my lord, they have issued.
Now you have no status.
That your lordship kindly, my lord, I have been terminated without any proper
Without,
inspection.
then you have filed a writ,
Yes.
challenge the termination order.
My lord.
So you go there, not here.
But in the meantime, during the pendency of my application, my lord, they have issued new vacancy, my lord. If that vacancy will filled up, my lord, I will be out, my lord.
He has a cause of action, my lord, this petition, my lord.
But your lordship kindly consider, my lord. I've been appointed.
Under which authority he can come, my lord?
My lord, that
Unless and until your termination is set aside. So what is your status now?
in the meantime, they filed, my lord, their affidavits, my lord.
I do not know what is the status of your application.
Lordship,
What is the merit of your
kindly
application?
protect me, my lord.
If
Otherwise, I will be, my lord, out, my lord. They have issued already, my lord. They have issued new vacancy, my lord.
I understand, but
Lordship, kindly
you have to
consider
challenge on the
question and ground.
how are you aggrieved person in this writ petition?
Lord, I have
Because you have to show a status now that you
At
are
present,
aggrieved.
at present, my lord, he has no status as well, my lord. This is the interloper, my lord.
I understand.
my lord, if I have been out, my lord,
You have already been out.
Survived, my lord.
You have already been ousted by the order of 22. It was not revived yet. 25, you cannot
I have
claim
not
that.
been given a chance, my lord. Matter is appearing in the list. My lord, I followed all the time, my lord. My lord, lastly, this petition was dismissed. My lord,
Whether
on
it is
16th
pending in the
June.
list now?
Yes, my lord.
Now is it pending in this
Yes,
list?
my lord, I filed application. Matter is appearing item number 71. Restoration application.
Item number 71.
Yes, my lord.
Today's list.
Yes, my lord.
Let both the matter appear together.
But in the meantime, your sub protection will be there.
My lord,
No.
I have an objection.
Let the matter appear together, dispose of the matter. Application 71, Sundre. You are for the state.
My lord, Mr. Neelapal Chatterjee is referring to
Mr. Nilapal Chatterjee.
হ্যাঁ,
Learned
শুনতে
count.
পাচ্ছি।
No, please take down. Instant writ petition is preferred challenging and vacancy notification dated 29/5/2025 issued by the SCFS Chachol, Malda. It appears that the present petitioner is the erstwhile MR dealer whose license was terminated by an order of the authority on 6th of September 2022. Challenging that order of termination, the petitioner has preferred another writ petition being WPA 3739 of 2023, which is running in the list of this court at list number 71, at item number 71. Full stop. It appears that the petitioner grievance cannot be considered singly in the instant writ petition, whereas both the writ petition, wherein both the writ petition is required to be heard analogously. Let the instant writ petition along with application in connection with WPA 3739 of 2023 appearing in item number 71 of today's list be appear under the heading to be mentioned.
Point of maintainability वाले can't put
Okay,
over.
under the heading to be mentioned on 19th of August 2025. Full stop. Point of maintainability raised by the learned state
Grateful,
council
my lord.
be taken on record. Be kept open.
Not give any effect. my lord.
I have given you date on 19th.
Yes,
Before your lordship rising, regarding item number 40, this is the content application today is returnable day. Matter not
My lord,
reached
this
today,
matters, my lord, I have
not
instructed.
reached today,
The
kindly taken up tomorrow, my lord.
Tomorrow.
An appeal has been preferred, my lord.
Till today, no appeal has been prepared.
Yes, yes, my lord. I am supplying the number.
Number 40 and 41.
41, 41.
You have preferred an appeal.
Yes, yes.
No, my
Well,
lord. Till today, no appeal has been prepared.
Number পেয়ে গেছি আমি।
Mr. Chatterjee is
Yes.
saying yes and you are saying no.
My lord, I have a number.
Finally,
I have a number, my lord.
this
Mad
page
number.
copy.
I am
What?
supplying. I am supplying.
You have a copy.
Lordship, lordship. I'll
Have a copy then if
Lordship.
you file an appeal.
keep some
Or
time,
is
my
there
lord.
any order like that? Very good.
Lordship, then, madam, kind of on Monday,
Monday it will be appear in the
no,
list.
Monday, madam, got down, madam.
Down can have.
Monday, maybe, madam, got down.
You preferred an appeal, my lord, is to
You serve a copy of.
Yes, yes, we praying for some more time, my lord.
Okay, okay. Yes.
Lots.
May not be.
I am taking for the extension of 80 I have filed an application. 80 was expired. I have filed an application in November 2000. Now they have issued the license, but other purpose is now still not there. If your lordship is not restrain them, they will be permitted.
Item number
70.
70
20.
under heading application.
Earlier I mentioned it was upgraded by your lordship.
It has not reached.
Correction. Eight matter, your lordship can give you Monday anytime.
Monday application would be taken up last. Monday here. Yes. Therefore application there. Application here.
Which matters are there on Monday? Well, my matter item number 40 matter.
থাকবে থাকবে
Item number 40, what can I do now? The appeal code has not reached yet. Okay.
Mr. Dara is so much complaint. Grateful, my lord.
অ্যাপিল করে স্যার কি করে অ্যাপিল করেন আমি বলছি নাম্বার পেয়েছি
দিয়ে দিচ্ছি আপনাকে
আমি